The appeal is dismissed. The bail bond of the accused is cancelled. Is directed to surrender honor before 25th July. Failing which, the IAC concerned will take him to custody for serving out the remainder of the term.
My lord, item 1, my lord, I am of the opposite party.
Judgment. For judgment, item number 2, CRA 198 of 2001.
The appeal is dismissed. The bail bonds of the surviving accused are cancelled. They are to surrender by 25th July.
Passing an order.
I see.
Both the late petition disposed of, but it has not.
This petition has already been disposed of on 8th March 2022. It need not be shown in the list. Right.
Yes.
Old matter item number 2.
None appears dismissed, non-prosecution.
Old matter item number 3.
Lord, here there is a delay of 43 days. Delay is cut down. Then the question has been referred to in page 2, my lord. But my lord, the difficulty is I'm having the petition only, and I have also seen the physical copy of your lord. There is only the petition. The annexers are not there. In view of the holidays or Saturday, Sunday, I couldn't get it from the department. So the demand is huge, my lord. So I pray let it be on the next week. In the meantime, I will collect the documents. In fact, the physical records of your lordship is only the petition is there. So I don't know whether the orders are there in the soft copies also or not. There's no discrepancy in the figures of production given in the appellant's balance sheet in RT12 returns. There are some, how many 10 questions referred to? That was raised, but page 2, these are the 2 questions that has been referred to your lordship for framing it and referring it to the tribunal for its decision. Page 2 of the hearing. These 2 questions have been.
20-year-old matter. Why should we hang
but,
on to this? I mean,
demands are huge and the documents are, I'll collect my.
nothing. Such a huge demand, no interest has been taken by the state for 2 decades. So suddenly demand can't become huge. You have to show some interest in the matter, please.
I beg only 2 days, my lord. In the meantime, I will collect it from the department because of the intervening Saturdays and Sundays, holidays. I couldn't get it from the department also.
Why is this question of limitation actually raised time and again? How are you sure it's only 46 days? What is the
The miss case 25 of 97, that's the delay condonation petition.
2001 it says, not 97.
No, initially it was OJC 97. Thereafter it was terminology TREB 2001. It was filed in 97.
So which means it must be a very old matter. Why did it get renumbered, I wonder?
In fact, I will also check up, my lord, whether this dealer is it's still there or not, because it might have been.
All right, at the request of counsel for the petitioner list on. When do you want it? Friday?
Next week, ma'am.
All right, next Monday.
Special weekly list item number 4.
So, my lord, the tax involvement is 5,000.
View of the insubstantial tax. Court is not inclined to interfere in the matter.
Special weekly list item number 5.
5, my lord, the question of law is at page 6. Whether in the facts and in the circumstances of the case, the transaction would be treated as interstate sale or intrastate sale or interstate sale coming under section 3A of the CST Act and making the dealer liable to pay tax under CST Act. May I take your lordship directly to page 23. That's the order of the tribunal. It starts from page 21, page 23, my lord may see. Towards the bottom, about 5 lines from the bottom, merely on the finding that the raw materials purchased by the appellant have been sold and transported in the same truck to the parties. So
Yeah.
Outside the state, no definite conclusion can be drawn. So that's, my lord, I have also verified. That's the only material available on record.
The state is seeking to question an order dated 9/12/1994 passed by the Orissa Sales Tax Tribunal. In SA 31-32, bracket C of 1993-94 by the impugn order dated 9/12/1994 for the years 1986-87 and 87-88 respectively. Full stop. The questions ought to be urged is whether the transactions in question would be treated as intrastate sale or interstate sale within the meaning of section 3 bracket A of the Central Sales Tax Act, thus making the dealer liable to pay tax thereunder. Question mark. From the impugned order of the tribunal, it seemed that the attempt at categorizing the transaction as interstate sale was only on the basis that, open quotation, the raw materials purchased by the appellant have been sold and transported in the same trucks to the parties outside the state, unquote. Paragraph. Clearly, there is no other basis for drawing an inference about interstate sales, when in fact there is not a single waybill produced by the state to show that the appellant had dispatched, that the dealer had dispatched goods as a consignor to outside state parties. Paragraph. This being purely factual, the court is not persuaded to frame the question as suggested by the state. There is no merit in the present petition. It is dismissed as such.
Special weekly list item number 6.
None appears dismissed, not possible.
Item number 7.
Seven is state.
Special weekly list item number 7.
Kindly pass so.
Okay, pass over.
Special weekly list item number 8.
Item 8, Malats, on behalf of Mr. Kanungo, no instructions.
Counsel petition states he has no instructions. Petition is dismissed.
Grateful.
Special weekly list item number 9.
No instruction, my lord.
No instruction. Dismissed.
For OP, my name may kindly be recorded. I am appearing for ICR, item 9.
Special weekly list item number 10.
The petitioner challenging the order of sub-collector Sonpur cancelling the lease in favor of the petitioner. The petitioner is a landless person and scheduled tribe person. Applies lease 30 decimal of land out of plot number 18. But the Tahsildar Binka, after due inquiry, settled the land in favor of the petitioner by virtue of the lease case number 28/98, and possession was delivered. And after demarcating the same, Pata also issued in favor of the petitioner, my lord. But that order has not been challenged by anybody else. But in pursuance to Annexure 4, my lord, the Tahsildar, the sub-collector cancels the lease by virtue of a law, complaint lodged by one Debasis Das, a political leader, without issue any notice, and also, my lord, without giving any opportunity to the present petitioner, my lord. My lord, kindly say annexure. Annexure 8, my lord, page 19. Page 19. As the following person are not in possession of so-and-so, plot number so-and-so, house site a given to them by lease case number so-and-so is cancelled by the sub-collector Sonpur on 15/2/2006, with a direction settle the land so-and-so. My lord, so far as, my lord, the present case is concerned, my lord, the sub-collector has no authority to cancel the same, lord. The Tahsildar is the sole authority. Second, my lord, without giving any opportunity to the present petitioner, he has cancelled the lease.
That order is not annexed. The order of the sub-collector by which the cancellation has been purportedly made, that is not impugned here.
But
That order is communicated to the petitioner by the Tahsildar in Annexure 8. So that order must be impugned so that
But-
you
but-
can have the right to say that principle of natural
Natural
justice
justice.
has not been followed. And we have not been, that order is not there. So otherwise, because the counter affidavit, your lordship may see that we have justified that it is a house site, he was not in possession, and that is why it is cancelled. Sub-collector has the authority, is the authority of the Tahsildar, it is all the Tahsils. We have denied the allegation that they are in possession or constructed a house there on.
kindly say Annexure 6, my lord, that the inquiry report of the local RA, he inquired that the present petitioner is in possession, he has constructed 15% some house some extent, lord. And he himself admit that the present petitioner is in possession over the suitable property. Kindly see Annexure 6, lord. That is the RI report of the
No, the
Local.
only question is, before cancelling the lease, was a notice issued to him or not?
That is what I am saying, your lordship. Had the sub-collector's order been annexed to this.
No,
petition-
but your counter affidavit, because
is
that's the
not.
main contention in the main petition.
Yes, we
The
have
counter affidavit,
justified
you
the
could have easily
cancellation.
said he was given notice.
And that is not there. Yes,
Ah.
your lordship is correct. We have justified the cancellation.
that is
by
on
saying
merits.
that Actually, the claim of the petitioner is not correct.
You see, the challenge in the present petition is to a communication received by the petitioner from the Tahsildar Binka, District Sonpur, stating that by an order dated 15th February 2006 of the sub-collector Sonpur, the lease given in favor of the petitioner of plot number 80, 81, 82, village Padipali was cancelled in lease case number 28 of 1998, since the petitioner was not found in possession of the plot allotted to him. What is that second line? It's not clear. In annexure 8.
8.
The lease of the list of the leaseholder, patta cancelled. The name.
Not only the petitioner, but also in many other cases. This
No. What is written there? It is cancelled by the sub-collector with a direction to settle the encroached house site land
As they are
remaining there more than 30 years back.
30 years back.
What is the next line?
Tahsildar promises to settle the land used as house site within.
Promises whom?
The occupants, probably.
No. Is this
But this
correct?
is a wrong
I'm not even
English.
sure this is
Yes,
correct.
Your Lordship is correct. Not properly worded.
Worded.
Any case, let them appear
So the
before the
short
sub-collector
ground on
and
which the challenge is
that
raised
cancellation
is that
proceeding may
notice
be
is not been
reviewed.
issued to the present petitioner prior to the cancellation by the sub-collector by the aforementioned order paragraph. While issuing notice to the present petition on 2nd March 2006, this court had directed status quo to be maintained. Pursuant to the notice issued, a counter affidavit has been filed by the Tahsildar Binka, where nothing is stated whether notice was in fact issued to the present petitioner prior to the order passed by the sub-collector on 15th February 2006, cancelling the lease. It is pointed out that the petitioner had been given the land at village Padipali for house site purposes, but he had not stayed there, but was staying at village Sahaj Bahal by encroaching on another government land bearing plot number 49. However, there is no averment that prior to passing the order dated 15 February 2006, any notice was issued to the petitioner or he was even heard. On that short ground, the impugned order dated 15 February 2006 of the sub-collector in lease case number 28 of 1998 is hereby set aside, and the aforementioned lease case number 28 of 1998 is directed to resume before the sub-collector Sonpur and be listed for hearing there on 7th September 2022. The petitioner will appear before the sub-collector on that date, along with the downloaded copy of this order. Sub-collector will thereafter proceed to hear the petitioner and pass appropriate orders in accordance with law within a period of 4 months thereafter. Till such time, the interim order passed by this court on 2nd March 2006 will continue. The court clarifies it has not expressed any view on merits. The petition is disposed of in the above terms.
Special list item number 11.
Item 11, my lord.
I am for the opposite party bank, my lord.
All right. None appears. Dismissal on prosecution.
Special List item number 12.
My lord, my name may be recorded only. I am for the opposite party bank.
Item
number
12.
12 is covered by your lordship's order dated 1st March 2021 in WPC number 12717. This is the forest development tax matter, my lord. One two seven one seven of 2004, my lord.
Where is that order, sir?
That order, right?
Counsel, the petitioner states that this petition is covered by the order dated 1st March 2021 passed by this court in writ petition civil 12717 of 2004. Accordingly, the present petition is disposed of in terms thereof.
Special List item number 13.
My lord, item 13, no instruction.
Counsel, the petitioner states he has no instructions.
Special List item number 14.
None appears to be dismissed.
Special item 15.
I am for the opposite party number 2 and 3 bank, my lord.
None appears.
Let me presence may kindly be recorded.
Special List item number 16.
But in this case, I am appearing for the bank, my opposite party, my lord.
None appears for the petitioner.
Item 16, I'm for the petitioner. I pray for one Passover, my lord.
All right, pass.
Special List item number 17.
In this matter, there is one order dated, this allotment of this canteen number 1 in the steel plant Raulkela is by virtue of this order, I have to take instructions of whether he is continuing or what is the status, or otherwise the sale people can tell about what is the present status. By order dated 29/9/2011, my lord was pleased to that I will continue with this premises, canteen number 1.
So for 11 years, you're continuing in the canteen.
But my lord, I have continuing prior to that. Considering all these things, it was allotted in favor of one Arun Singh by virtue of his our power of attorney and affidavit. I am continuing. Considering all these things, I have been allowed to continue. And thereafter, I am not able to, last 2 days, not able to get him contacted. Only sale people already appeared, and I have served the copy to them. But they will tell that what is the status present.
Who's appearing for them, sir?
Vidyadhar Pradhan and
Just pass it over. Call them to us.
Special item number 18. Item 18.
Ask them to remain present, sir, the sale lawyers. I'm for open number 3, my lord. None appears for the petitioner. Dismissal of prosecution.
Special item number 19.
None appears. Dismissal of prosecution.
Special item number 20.
My lord, in item number 20, similar order was given in a covered case.
Whom are you appearing for?
For petitioner. So, my lord, for the petitioner.
All right. Same order.
Special item 21.
21, my lord, in all these matters, the question is whether the sale of tender papers by the executive engineer to the contractors, that comes under.
Amounts to sale. How can it be a sale, sir? Questions have already been framed.
Yes.
No questions have been framed. You say the recent revision petitions are directed against. Orders of the income tax, so Orissa Sales Tax Tribunal in appeal numbers 55 and 129 of 2010-11. The questions ought to be urged.
The demands are also meager money.
Then you say in view of the fact that the tax effect in these petitions are insubstantial. There's also delay in two of the matters.
There's some days delay, my lord.
Or court is not inclined to hear.
All these four, my lord, similar.
Sorry?
All these four tagged up are similar, my lord, for different
Questions
years.
of law left open for decision some other purpose. The petitions are dismissed.
Special weekly list item number 22.
Item 22, my lord, no instruction. In the meantime, petitioner was dead.
All right. It stated the petitioner is dead and they have no instructions. Petitions are calling dismissed.
Special weekly list item 23.
Petitioner seeks leave to withdraw this petition. Dismiss this withdrawal. The appeal is also dismissed.
Special weekly list item number 24.
24.
None appears dismissed and opposite.
Special weekly list item number 25.
None appears dismissed and opposite.
Special weekly item 26.
None appears dismissed and opposite.
Item 27.
I am for the opposite party.
None appears dismissed and opposite.
Special weekly list item number 28.
My lord, item 28 on behalf of Prasan Kumar Mishra, my lord. My lord, the Learned Council petitioner brother has been died, my lord.
What's the matter about, sir? Let us see. It's a 2012 matter.
My lord, challenging inaction of the land acquisition collector, my lord.
Inaction about what?
My lord, hour to the civil code under section 18 of the Land Acquisition Act.
Reference matter, there is a stipulated period within 46 days. They have to lodge objection. Then only the LAO will refer the matter on section 18 for adjudication. If they have not filed the objection within the stipulated period of 42 days, even 1 day delay will not cure the defect. So that must be there is no counter.
No, it's already forwarded for
Your Lordship,
adjudication.
may I pray one thing to you? Lordship may direct that if it is within the time limitation.
No, it's already been referred, it says. Let's see, annexure E2. Look at the government in counter affidavit, page 32.
Counter affidavit is not, there is a counter.
All right. In the counter affidavit, it is stated that
it is already, so it is
opposite
in
party number 2 has already received the petitions under sections 18 and 30 of the Land Acquisition Act 1894, dated 19 December 2001. And the said petition has been forwarded to the court of the civil judge, bracket senior division Kujang, by a letter dated number 1308, dated 7th November 2015 for adjudication. There has been this counter affidavit was filed way back on 8th December 2015, and there has been no rejoinder filed there too. In that view of the matter, the main prayer in the present petition does not survive. Full stop. If the said petition referred to the civil judge senior division Kujang has not already been disposed of, it shall be disposed of in accordance with law within 6 months from today. A copy of this order be sent to the civil judge senior division Kujang by the registry forthwith. The petition is disposed of.
Special weekly list item 29.
None appears dismissed, not prosecution.
Special weekly list item number 30.
The 30, I am from OP3, sir, from bank.
None appears dismissed and not prosecution.
Special weekly list item number 31.
Brief has already transferred lordship, but our name is deleted on behalf of Mr. Somnath Mishra.
Who are you, sir? What is your name?
Joseph Mohanty.
Joseph Mohanty, appearing on behalf of Mr. Somnath Mishra, states that the brief has already been taken away from them. None appears to the petitioner. Dismissal not prosecution.
Special weekly list item 32.
None appears to dismissal not prosecution.
Item 33.
Same order.
Special weekly item 34.
My lord. Advocate for the opposite party, Mr. Jay Patnaik, is suffering from pharyngitis.
None appears to the petitioner. Dismissal not prosecution.
Special weekly item 35.
My lord, I may be allowed through VC, ma'am.
Yes.
And I am sorry to submit that my brief is missing somewhere.
That's all right.
So-
Whenever you find it, you can. Counsel, the
My
petitioner
lord,
states
after-
that the brief is untraceable. The petition is dismissed from non-prosecution. As and when the brief is able to be traced, an application can be filed for revival. Right.
Special weekly item 36.
None appears dismissed from non-prosecution.
Special weekly list item 37.
One more, my lord. In item 35, I want to pray one thing more, my lord. I may be allowed to collect the same from the registry, my lord. It will
That
be
is up to you, madam. You do whatever you have. Yes.
37.
36.
36.
My lord, in 36, it has become infructuous.
Infructuous. Counsel petitioner states it's infructuous. Disposed of.
As we have purchased the land.
Item 37.
None appears dismissed from non-prosecution.
I am for the opposite party.
Special weekly item 38.
Well, I am filing memo. The case may be not present.
Counsel, the petitioner hands over a memo stating that he does not wish to press the petition. Dismissed is not pressed.
Special weekly item 39.
Item 39, my lord, I do not have any up-to-date instruction from the petitioners.
All right. Counsel, the petitioner states that he has no instructions.
Published, my lord.
Special weekly item 40.
None appears dismissed. Not pressed.
Special weekly item 41.
May I please, your lordship? The petition has been referred this writ application challenging the order of the Law and Labor Court under Annexure 1, wherein the Law and Court below, though passed in favor of the petitioner to reinstate the petitioner in service with the continuous service, but without any back wages. But at the time of order, he was superannuation, my lord. And the award has passed on 25th February 2012, my lord. And in their date of superannuation, 7th February 2012, my lord. So when the award is passed, if the award not be executed, that on the same month, my lord, he was superannuated from service. Though he only get any benefit for the back wages, my lord. Only in lieu of reinstatement, some amount should be given to the petitioner, my lord. In the petition was joined as cane assistant in 16/12/1992, and subsequently he was suspended and a proceeding was continued. And after suspension, she was.
Pass it over. Who's appearing for the opposite side? We'll pass it over.
Special weekly list item 42.
My lord, item 42, I am for the opposite party number 7.
All right. None appears dismissed and non-prosecution.
My lord, I'm appearing for opposite party number 6.
Special weekly list item 43.
43 minutes, I'm appearing for opposite person. Or none appears dismissed and non-prosecution.
Special weekly list item 44.
Item 44, no instruction for the
No
petitioner.
instructions.
No instruction. Yeah.
Special weekly list item 45.
None appears dismissed and non-prosecution. What is the
Special weekly list item 46.
none appears dismissed and non-prosecution.
Special weekly item 47.
None appears.
Item 47, no instruction.
No instructions dismissed.
Special item 48.
48 is a single bench matter, my lord. This matter related to recognition and a permission of the school, my lord.
List before the learned single judge on 5th September.
Special weekly list item 49.
Then may I please, my lords. My lords, as per the direction of this honorable court, the petitioner had deposited a sum of 11 lakhs and odd, and my application for OTS, very small fare, my lord, was rejected. That is why I am before my lords. Now they say that it will come under the OTS 11, my lords, OSFC. My client had approached them.
You withdraw this, sir.
My lords, my claim was that, my lords, I deposited the requisited amount 10% for OTS 7 consideration under OTS 7, my lords. That was rejected. Now they say that no, you will come under OTS 11, my lords. Orally they told me.
Anyway, sir, you withdraw and you receive that.
My lords, I have
Petitioner states
deposited
that
substantial amount I
whatever
have
they
paid.
will adjust that, sir. You have deposited with them only, no?
No, my lords, I have given to the auction purchaser who had taken auction, my lords.
Whatever, sir.
That is as per the order of this honorable court, my lord.
Right.
12/5, my lords, to 2014.
That's fine.
My lords.
Therefore, that will be accounted for, sir. If you've given it to the auction purchaser, that will be accounted for while dealing with your OTS application.
My lords, my small prayer is that I will approach them, let them consider whether I am coming under OTS 7 or 11. That is the dispute.
Or Lords, may I direct in the prevailing OTS application as per the rules.
Answer: the petitioner seeks leave to withdraw this petition with liberty to approach the opposite party for settling the dues under the prevalent one-time settlement scheme. Without expressing any view on merits, the court permits the petition to be withdrawn. And
My lords, the amount may be adjusted.
Yes, sir. Paid for. The amount already paid by the petitioner will be accounted for while considering the case under the OTS.
Yes. Second read petition, I am opposite. Connected read application, man. I am opposite.
You say the connected read petition disposed of in terms of the order passed today in 22779 of 2012.
My lord, the connected, may I please, my lord, the connected read application, my lord. I am for the petitioner, my lord. In this case, the mutual transfer agreement was, the OSFC agreed for mutual transfer of the unit. My lord, we have deposited 2,40,000 along with processing fee of rupees 3,000, my lord. The mutual transfer could not be acted upon. And my lord, in the meantime, my money is with them, my lord.
You can approach them, sir. It will be open to the petitioner to approach the OSFC for return of the monies paid in accordance with law. Right.
What a big excuse, my lord. 42, my lord. Just
tell us what it is.
My lord.
Please tell us, sir.
42, my lord.
Yes.
Yes, my lord. The matter relating to disbursement of compensation, my lord. Our grievance is that though under one notification,
you have to go under the concerned statute. What is this acquisition under the Land Acquisition Act?
Land Acquisition, yes, ma'am.
You have to go under the statute, sir.
It is under the old act, my lord.
That's right.
Only,
Section 18. You have to seek a reference under 18 for that.
Only reference under section 18 is not, there is no provision of appeal.
So you made the reference or you did not make?
For appeal. Section 54 is there.
Yeah.
54
There
here,
is
ma'am.
54 is
54
there.
here.
Against
Yes, yes.
the order of the sub-judge.
Absolutely.
Section 54 is the remedy.
54 here.
Yes.
Yes, it is not, it has not yet been referred. I
Not
say,
yet referred.
yes.
No, it's for you to ask for reference.
What I say, my lord.
Counter that we have referred it.
Yes.
No, they have not referred yet. Let them refer, my lord, our case on that.
This is Trilochan Godana.
Yes. 1249949. 1249946.
My lord, your lordship may kindly have a glance at page 2 of my counter affidavit. Counter affidavit filed by the land acquisition officer.
Yes.
This
before
valuation has been fixed in the first paragraph.
Before my learned friend starts,
so
my
the
lord.
market value of the land is fixed at lower rate. Flat rate of rupees 11 lakhs per acre have been paid for all classes of land measuring so and so. The market value of Nadicho,
Nandicho.
alias so and so village has been approved by the government in Steel and Mines Department, and it was also discussed in detail in the first.
When did you seek reference?
My lord,
When did you file an application?
no, my
seeking
lord. No, I
reference?
have not yet filed for reference, my
Sir,
lord.
you
Then
already
it is
gone
time
past the date, sir. Then
Because my lord, I have before my lord, I am before the villagers, my lord. When
everybody, sir, everybody is villager, everybody is poor, but the
no,
lawyer.
not poor, my lord. I am before
no,
my
but the
lord.
lawyer knows the law. No?
We are before my lord.
No, you are, of course, sir. We are honored that you are before us. We are very obliged. But you have to be also before the right authority.
You cannot escape from the limitation point.
Correct.
Even if a case is filed, limitation is fixed.
Because my lord, with due apology, for under one notification, 4 villages, the land of 4 villages have been acquired, my lord. One village have given.
What is the date of the award, sir?
Award, my lord, because before award I have filed.
What is the date of the award? You can't ask for higher compensation without there being an award.
No,
unless there is an award, how can you ask for higher compensation?
No, higher company in the sense, my lord, they have given.
Sir, is there an award? Let's go step by step. Is there a land acquisition award?
Not, my lord.
You don't know.
No.
Great.
Because before award.
So without that basic information, we cannot proceed.
No,
sir.
before, my lord.
No, you can come before, after everything. There is a Land Acquisition Act. Unless there is an award, the question of paying a higher compensation does not arise.
Higher compensation, but they have paid higher for the self-same land. They have paid more.
Sir, is there an award? Please answer this question. If there is no award, this whole prayer is premature.
Then, my lord,
counsel with the petitioner is not able to answer a simple question whether a land acquisition award has been passed by the land acquisition collector. Full stop. Without there being an award, the question of entertaining any prayer from the petitioners for single quotes higher unquote compensation simply does not arise. In that view of the matter, the petitions cannot be entertained and they are disposed of as such.
May I pray, my lord, one thing, my lord may grant liberty to approach the land acquisition.
No, sir. Sorry. Without all basic information, no question of liberty. Yes.
Because, my lord, it is at 12. Nobody has.
All right.
Special vehicle list item 50.
None appears dismissed or non-possible.
Only, my lord, may I pray, my lord, permitted to withdraw, my lord, without any.
Not anymore, sir. No, that is gone now. Yes.
Special vehicle list item number 51.
Pardon, my lord, item 32, I have been obstructed in way.
No, you will end of the list, sir, not like this. Counsel the petitioner.
Item 31, I am appearing on
51.
Praying that he wants to withdraw the petition, dismissed as withdrawn.
Special vehicle list item 52.
None appears dismissed.
This is a covered judgment passed by your lordship.
No, it is not at all a covered judgment. I will submit it.
I'm supplying the.
I will submit it for your lordship. What has happened? Your lordship may kindly have a glance over the impugned cancellation order that is dated 11/8/1998, which is at page 27, annexure 5. And the petitioners purportedly purchased the suit land in the year 2005 and 2008 by annexure 3 and 4. So 7 years after the cancellation, they have purchased it from the original lessee is not before your lordship and challenging the cancellation. And recently in the case of Mrs. Pami Ratha, your lordship has, that he has a liberty to claim compensation against the vendor.
Correct.
But he cannot challenge the.
Your lordship can see there is also a judgment of this Honorable High Court. If the vendor of the petitioner was neither issued notice nor included as a party in the proceeding, so without making any inquiry of the affected party.
Anyway, you will get no relief, sir.
7
You have to
years
get that set aside.
You
so
have
I
purchased a
purchased from
cancelled
there are 3 purchasers, my lord. 6, option number 6 and 7, from which whom I purchased the land.
So when did you purchase?
I purchased in the year 2008, my lord. So
when was it cancelled,
prior to cancellation,
cancellation was 1987.
So it is not known to everybody, my lord.
Correct,
Neither your lordship can see
Correct.
the first purchaser who has mutated the land under in his favor under annexure 1, my lord. That is the corrected.
He could not have
mutated
conveyed
RY.
title. If he could not convey title, then your vendor also could not convey title to you. And none of you has a valid title because of this.
Even
So only
before-
remedy is to go for declaration.
My lord, your lordship can see that judgment which was already passed, wherein it is categorically held. In paragraph 10, that is your lordship's judgment. There the
No,
direct
sir. There the
purchase.
cancellation was after the purchase.
So now I'm reading the another judgment of this Honorable High Court.
Here the cancellation was after the
After
purchase.
the purchase.
Your lordship can see. Thus, it is evident that learned additional district magistrate did not conduct any inquiry to find out as regards the persons who were likely to be affected by the cancellation of lease. As a result of such omission, the
So you are not
petitioners
even there in the
who are-
picture. So how will you be affected?
Exactly.
So,
He was
my
not
lord,
in picture when the
here-
cancellation order was
here
passed.
what
How he is
happened-
likely to be affected?
Here, my lord, even if the lessee already already asked that I have already transferred the land, but the vendor, the first vendor who has mutated the land in his favor under annexure 1, that is the mutated RR in his
The
favor,
admitted
that
facts
is
are that
Prasanth
the-
Kumar Dalai, OP number 6, my lord. So neither he was issued notice nor he given a opportunity at all. And the impugned order itself said provides that the lessee already transferred. Your lordship can see page 29 of the impugned order. Paragraph 5, last sentence. It has also been admitted by the OP that the land got on lease has been transferred by him. So who is the affected person? The statutory, your lordship quoted in the judgment, the affected person must be heard, and after 14 years or no initiation of a proceeding.
My lord, affected
So
person
here-
means
Yeah.
the person.
Affected means at that time, my lord, he was not given any opportunity to the vendor. So my learned friend, what is submitted, my lord, if the vendor himself, my vendor or earlier vendor, OP number 6, was implemented
They
as
should
a
come before
party
the court, sir.
or was
They should
heard.
come before the court. Yes.
Your lordship kindly, particularly that judgment which was reported in paragraph 2010 to OLR 41. Here, one after another purchaser was paragraph 10, last portion I have read. The revisional authority neither inquired nor given any opportunity to the affected party at that time also. And it was initiated after 24 years of the year. That is also violation of a clear second proviso of the under section 7A of 3 summatory revision provision.
Which page, sir? You're giving some Hindu Marriage Act judgment. Long after. Yeah. Petition went up.
Kindly have a glance.
Lordship, as to why the delay, I will submit my lord, paragraph 7 of my writ petition.
No, one minute, we'll just ask. Yes.
Your Lordship may kindly have a glance. The impugned order is of the year 1989.
Correct. 1998.
I'm sorry, 98. I'm very sorry.
And he
Prior
purchased
to
it in
that-
2008.
Yes, and prior to that, there is one cell deed. That is at page, paragraph 4 on 27/4/1984. That is in favor of one Prasanna Dalai, opposite part number 6. He is not before your Lordship. Then the subsequent cell, he is the third purchaser. The subsequent cell deeds are after the order. So this Prasanna Dalai could have come to court and say that I was a necessary party, I am an affected party. He is not coming to court. So he has sold the property before the order, and thereafter there are two cell deeds, by annexure 2 and 3, and he is the third purchaser. So far as this petitioner who is before your Lordship is concerned, his interest was not at all affected on the date when the ADM passed the order. So he has no locus standi to pass. Only his vendor's vendor.
This judgment seems to indicate, just show him the judgment. So you don't give copies of judgment. Even for us, we don't get copies. Your friend also does not get copies. You have been so kind, sir, to bring one copy of the judgment, one book. Correct? We don't get copies. He doesn't get copies.
Sir, sorry, my lord.
Now you have finally understood. It takes so long for you to understand this.
Next time we will.
Next time. All right. We'll vacate the stay then. Next time we'll come the day after tomorrow.
Yes, it is there, but if your Lordship will see that here the person, the first vendor, that is the opposite part number 6, he was there in the picture. But after this, there are series of decisions your Lordship has passed. This is an old decision of 2010. But and recently your Lordship has passed just 3 days back that if the petitioner's locus standi, in order to find out the locus standi of the petitioner, he came to picture in 2008, and by that time the lease is already cancelled 10 years back. So what is his locus standi to challenge? He has knowingly purchased a cancelled lease cancelled plot.
My lord, the statute itself provided, I have quoted the portion of the statute 7A3 in page 6 of my writ petition, where it is categorically held that provided that no order shall be passed under subsection unless the person affected by the proposed order has been given a reasonable opportunity of being heard in the matter. Thereafter, provided further that no
Sir,
proceeding on the
how is the ADM
Now,
to know?
here,
1 minute.
Here,
How-
my lord, my humble submission, my lord, before your lordship, that even if the revisional authority known very well that the land already transferred by
How
the
will he
lessee.
very well know? How will he know?
The impugned order itself said, my lord.
What?
That the lessee appeared and said so he has already transferred the land.
Where is that?
The impugned order, page 28. '29, my lord. 29, paragraph 5. Paragraph 5, last sentence. It also been admitted by the OP. OP means only the lessee who has been pleaded as your OP. That the land got on lease has been transferred by him. So after transfer, he lost his interest over the land.
No. All that you're now adding.
So who is purchaser? Who is in possession? They are
Anyway,
the affected party.
this
as per
person
the-
is not you. The transfer is not transferee is not you.
Yes.
And how is the ADM supposed to anticipate who that the
After 10
transferee
years, who will purchase?
So,
transferee further sold and all
So
that?
at that time, my lord, the OP number 6, also as a purchaser, he mutated the land and corrected the record of rights in his favor under Annexure 1.
Yes.
The copy of R1.
Yes.
So now, if the initial vendor would be as a party and he would be affected party would be noticed in the revisional case. So I have no case at all. So since the initial vendor was neither a party nor given any opportunity.
No,
so
initial vendor is the lessee, sir. He was a party. He appeared before the ADM.
I purchased from the second purchaser and third purchaser.
So how will ADM supposed to know who is the second purchaser and third purchaser, sir? How will he possibly know that?
In the year 1998, is open.
Six. Yeah. You show me that book. No notice was issued to the opposite party, 6 vendor. This is the distinction. There, even the vendor did not get notice. Here, the first vendor, first lessee did get notice. There, he did not, even the vendor did not. See the challenge, the present petition. is to an order dated 11th August 1998, passed by the Additional District Magistrate, Bhubaneswar, in revision case number 897 of 1998. The above revision case was initiated in section 7, capital A, bracket 3 of the OGLS Act 1962 and was in respect of a lease of AC 1.300 decimal of land in plot number 1400/1756 under Khata number 420, bracket 325 by 124 of Moza Pathargadia. Stop. The short ground on which the petitioner claims to have purchased the land in question under a registered sale deed dated 25th November 2008 from a vendor Srimati
Pratima Das,
who in turn appears to have purchased the property in question from
Prasanna Kumar Dale. Arrested dated 16/11/2005. 16th.
On 16/11?
2005.
Prasanna Kumar Dale. But if you look at that annexure 2, it's in Odia. It says
Yes.
Prasanna Kumar Dale, is it?
Yes,
Correct.
yes.
From one Prasanna Kumar Dale. Full stop. The original lessee of the plot was what's the name of the original lessee, sir?
Daitari Naik.
Daitari Naik.
The original lessee was one Daitri Naik. At the time that the aforementioned WL case number 897 of 1998 was taken up. Full stop. In other words, there have been two subsequent transactions, more than two subsequent transactions of sale after the cancellation of the lease by the impugned order dated 11/8/1998. Paragraph. Relying on the
Lessee transferred in the year 1984 to the Prasanna. OP number 6.
One thing I want to submit before your chief, so far as the sale deed of Prasanna Dale is concerned, which is allegedly prior to it, that is not annexed. There is only averment to that.
Correct.
That is not annexed. I don't know why he has not annexed it.
By the impugned order.
The Prasanna Dale already mutated and his ROR.
But the
correction of
date
ROR.
of sale deed is to be
by the order
examined. Na? You should have comforted with the sale deed.
December
copy.
1974 of the Tahsildar Bhubaneswar was cancelled. Paragraph. Relying on the decisions in Chandan Kumar Safety with the State of Orissa, 2010 2 OLR 41, and a recent decision of this court dated 20th April 2021 in WP Civil 25099 of 2012, bracket Pratvati Kumari Rajguru versus State of Orissa. Learned counsel, the petitioner contends that the impugned order is violative of the first proviso to section 7, capital A, bracket 3 of the OGLS Act, inasmuch as notice was not issued to the present petitioner. No, to the present petitioner, at the time the impugned order was passed by the ATM. Paragraph. the facts which are not in dispute are that the present petitioner is a purchaser from a person under registered under from the facts which are not in dispute are that by the time the petitioner purchased the land in question under registered sale deed dated 25th November 2008, it had already changed several hands even after the cancellation of the lease by the impugned order dated 11th August 1998. Paragraph. According to the petitioner, the first transaction vis-a-vis the land in question, after lease was granted in favor of Taitri Nayak on 26th December 1974, was a sale effected on 27th April 1984. In favor of one Prasanna Dalai. So, however, that sale deed has not been placed on record. So it was the said Prasanna Dalai who was supposed to have executed a sale deed in favor of Srimati Pratibha Das on 16th December 2005. Paragraph. At the time that the impugned order was passed, that is in 1998, the only person who could have been affected was the said Prasanna Dalai, who had got a registered sale deed in his favor on 27th April 1984. Stop. However, as is obvious, the said Prasanna Dalai was not made a party to any of the proceedings, and he has not come forward to challenge the impugned order of the ADM. Paragraph. In Chandan Kumar Sethi versus State of Orissa, this court noticed that the first vendor, the first purchaser of the land from the original lessee had not been issued notice by the ADM before the cancellation of the lease deed. And in those circumstances, invalidated the order of cancellation of the lease. Full stop. In the present case, in the impugned order, the ADM notes the contention of the original lessee that open quotation, the land got on lease has been transferred by him, unquote. Clearly, however, the lessee did not provide details of the person to whom he had sold the land. Full stop. Therefore, there was no occasion for the ADM to have issued notice to such person. Full stop. In any event, for the purposes of the proviso to section 7 capital A bracket 3 of the OGLS Act, since that was the only single quotes affected person, unquote, at the time of passing of the impugned order, comma, if at all it was such person who could have, such person, comma, which in this case is Prasanna Dalai, comma, who could have challenged the order of the ADM. Paragraph. As far as the present petition is concerned, his vendor did not have any valid title. Her vendor, that is Pratima Das, herself did not have any valid title to convey, since Pratima Das's vendor, that is Prasanna Dalai, himself had no valid title to convey. Stop. Both these sales were therefore non-est in the eye of law. Paragraph. Consequently, the court does not find the decision in Chandan versus State to be helpful to the petitioner. as far as the decision in Pratavati Kumari Rajguru Supra is concerned, the facts of that case reveals that the purchase had taken place prior to the cancellation of the lease. And therefore, the court was of the view that notice ought to have been issued to the purchaser. Stop. Here, the purchase has taken place long after the cancellation.
Paragraph 7, my lord, I have given the reason as to why at the time when he came to know.
That's all right. We're not on the delay in filing the petition, sir. We're on the locus. And as in the circumstances pointed out above, no valid title could have been conveyed to the petitioner in the eye of law. Full stop. The petitioner, therefore, has no locus standard to challenge the impugned order of the ADO. For the aforementioned reasons, the writ petition is dismissed. The interim order passed with this court on 10th January 2014, is hereby vacated. All right. Both petitions for the reasons stated in 24975/2012, the present petition is also dismissed. This Hindu Sharma is a subsequent purchase, is it?
Same. Both the cases are same.
Oh, different parcels of land.
Yes.
Another purchaser.
Another portion.
Purchaser, same order, same affected by same order, but another purchaser purchased another portion.
That's what, another portion. Correct.
May I pray your lordship to report this judgment? Because
All right. Make this report.
Special weekly list item number 53.
None appears dismissed or not possible.
Special weekly list item 54.
53.
53 dismissed or non possible.
Item 54.
By the order dated 19th February 2013, the question of law has been framed. Basically, this question relates to the legality of escape assessment under section 43 of the Orissa Value Added Tax Act in absence of
He sent him, he will not be able to find out. He's taking his own time to go there. Jaldi jana hai.
By the order dated 19th February 2013, the question of law has been framed. The question of law relates to legality of the escape assessment under section 43 of the VAT Act in absence of any acceptance of the self-assessment. Your Lordship, in fact, this question has been answered by Your Lordship in that case of automobiles. Your Lordship, what to tell him? for the Honorable Apex Court, and the matter is posted to day after tomorrow. So,
All right.
I'll give him that SLP case status.
Yeah. At the request of, it appears that the questions framed are covered by the decision of this court. It's still not reported, is it?
My lord, I've not found out. My lord. Still not reported.
Only in Manupatra. In Keshav Automobiles, State of Orissa, Manu/OR/0580/2021. Our counsel for the petitioner points out that SLP civil number 9823-24 of 2022, challenging the said order, is listed before the Supreme Court of India on 13th July 2022. Accordingly, only this petition or all the connected ones?
My lord, no, this should cover, my lord, item 54, 55, 56, and item number 60.
Right, all four. Put down all four.
60, there is a delay of, my lord, 28 days only.
All right. All the four, the list on 3rd August.
Special vehicle list item 57.
May it please the Lord. I may be permitted to submit on behalf of Mr. Sumit Lal, my lords. Here, my lords, the petitioner before Lordship is a manufacturer and sells rice bran oil. For the purpose of production of rice bran oil, he effects purchases rice bran from the registered dealer as well as from the unregistered dealers. Now, by paying tax. Now, for the period 1/4/2005 to 30th of November 2006, he claimed full ITC. Now, his assessment was completed under section 42. Thereafter, my lords, what happened? In 2006, the enforcement wing, Balasore, they came and they gave a report basing on which the assessment was reopened for this period, that is 1/4/2005 to 30th of November 2006 under section 43 of the OVAT Act. Now the assessing officer relies upon, Lordship will kindly be pleased to see the
So there's only
relevant.
one limited question, sir. 5th February 2013. You saw that?
Yes, that is why I am taking your Lordship just for 1 minute, my lords. Lordship may kindly see the assessment order. What he did, my lords, he relied on two manufacturers. Lordship will be pleased to see page 31. Page 31 of the brief. It has been reported by the SCCT enforcement that the dealer has yielded 16.10% of rice bran oil during the tax period so and so, and 14.44% during 1/4/2006 to 30th of November 2006, where other solvent units, that is SNM Business Private Limited, Solvent Division, Balasore, and Balasore Solvent Private Limited, Balasore, have yielded 20.85% and 22.10%. So therefore, he disallowed my ITC to the extent of 30% and raised a demand of rupees 74%, as against which I preferred first appeal. Then, my lords, in the second appeal, lords will be pleased to see Annexure 6 that is at page 68 to 73.
I'll just take your lordships to the relevant observation of the tribunal who admitted the fact that yes, the forums below ought not to have accepted blindly the report that the two other business manufacturers. But what they did, my lords, although I laid all the evidences to show by Annexer 5 in my written submission, the tribunal, my lords, remanded it back to the assessing officer to see as to the percentage of yield. And
What is wrong with that, sir? How else? This is a fact finding, it has to be done.
My lordship will kindly see. If all the evidences have been laid, I'll take your lordship to a judgment of this honorable court. This honorable court, in a case reported in 336 ITR, page 112, relevant page is at page 5. This honorable court held that if all the evidences are there, the appellate authority should not remand it. Page 5, lordship will kindly see. I am giving the judgment to my learned friend. Page 5, I have marked it also. Law is well settled that once the materials are available on record.
Which materials are available? We don't know what's the yield.
Yes, that is why I am saying yes. What evidence I laid, that is your lordship will
that is your evidence, sir. If the department
my evidences.
When they say once materials are available, materials from both sides.
Both sides.
Here the department has not laid any evidence.
Department did not file any cross objection, my lords.
No. Now when it goes back, the department might place on record materials to show that the yield must have been higher.
Yield must have been
higher.
My lords, department having not filed any cross objection. They are having, my lords, after
why
8
did you
years.
file a cross exception? I don't understand. The assessing officer says,
wait.
You have shown an yield of 14%.
Yes.
If you compare it with two other units, it should be higher.
My lords, why should this be compared with two other units? My objection is with that. What was there with the left with the assessing officer? Why he did not do it himself?
Assessing officer is entitled to doubt the correctness of any claim made.
He may doubt, but doubt will not replace with the suppression, my lords.
Exactly. So
yes,
yeah. So
both the first appellate authority as well as the assessing officer.
Sorry, sir. It's only a remand.
My lords, remand is after 8 years. Remand is after 8 years.
Yes.
And also will kindly see. Just one, if the finding is, should not have, just a minute, my lords. '73. I have in my. May I place, my lords?
Yes.
The finding of the learned SCST in determining the yield at 20% has got no logic, and the said findings is not supported by any scientific calculation or authority, and simply deciding the matter on the certificates issued by 2 units. Had they confronted me, my lords? These are the certificates. What do you say? There has been no confrontation. 2 units of Balasar district will not hold, and for my knowledge, my lords, these 2 units have been already closed 5 years, 6 years back. Hold good to fix the percentage at 20%. Further, the claim by the dealer 16.10% for the year 2005 and 6 and 14.44% for the current year is also not supported by any logic.
Yes, exactly. That's the whole point, sir.
By any logic. And hence it's a fit case for remanding back.
Correct.
Then, my lords, 1 minute, my lords. Lords, you may kindly permit me to place the other part. Remitting back the percentage of yield of oil from the rice band determined by the department at 20% got no logic and not supported by any authority. The assessing authority, the second one, my lords may kindly see the second one. That is B. Lords may kindly see. The assessing authority also, without verifying the matter properly, blindly accepted the certificate issued by a number of units of Balasore district is also not justified. Having said this, my lords, having said this, why should they remain, my lords? And it is also a last fact-finding authority. And Lordship will kindly see that is also in the LCR. What evidence? Nobody stopped the department to lay evidence before the tribunal also. They did not file any single evidence to show that, yes, the percentage of yield is so and so in the case of so and so. That is not there. In my written submission, that is Annexure 5, I have given all the evidences. And nobody prevented the department to confront these materials. Now, after 8 years, from the date of assessment year, the tribunal will remand it back to the assessing authority for determining as to the percentage of yield. What is the logic, my lords?
Yeah. See, present petition by the SSC challenges an order.
Lordship may also see under section 42, when the assessment was completed, the assessing officer has accepted my figure. That has not been, that remains undisputed. Now, on the basis of the enforcement doing, who said that, yes, S&M business and Balasore solvent, their yield is so and so. They are being small units. You are a big unit. So your percentage of yield must be big. That is the thing, my lords.
All right. The challenge of the present petition by the SSC is to an order dated 30th March 2012, passed by the Orissa Sales Tax Tribunal, Cuttack, bracket tribunal. In second appeal number 136, bracket 5 of 2011-12. By the impugned order, the tribunal partly allowed the aforementioned appeal by the SSC. No, disposed of the appeal filed by the SSC for the tax period 1st April 2005 to 30th November 2006 and remanded the matter to the
assessing officer.
Assistant Commissioner of Sales Tax, Sambalpur 1 Circle. For making a fresh assessment in terms of the observations of the tribunal. Paragraphs. The background facts are that the SSC is the SSI unit engaged in manufacturing rice bran oil from rice bran. Full stop. Originally, for the period in question, the SSC is assessed under section 42 of the Orissa Value Added Tax Act 2004, bracket VAT Act. So, on receipt of an audit visit report, the assessment was reopened under section 43 of the VAT Act, alleging escapement of tax. As per the AVR, the dealer had claimed input tax credit bracket ITC illegally by showing the yield of bran oil to be very low. And there was also allegedly stock discrepancy.
That is the allegation, my lord.
Allegedly, we have said, sir.
Yes,
please.
sir.
Paragraph. The percentage of yield of rice bran oil claimed by the SSC was 16.10% and 14.44%. However, in the assessment order dated 28th October 2009, passed by the ACST, it was noted that
Page 31, my lords.
yes, two other oil solvent units had shown yields of 20.85% and 22.10% respectively. Consequently, the average was taken as 20% and applied to the SSC. And on that basis, a demand was raised. Paragraph. After the SSC's appeal was dismissed by the Deputy Commissioner of Sales Tax, bracket appeals, bracket DCST, the SSC went before the tribunal with the aforementioned appeal. In the impugned order dated 30th March 2012, the tribunal held that the finding of the ACST in determining the yield at 20% open quotation has got no logic, and the said findings is not supported by any scientific calculation or authority. And simply deciding the matter on the certificate issued by 2 units of Balashid will not hold good to fix the percentage at 20%. Full stop, unquote. As far as the dealer claiming the yield to be 16.10% for 2005-06 and 14.44% for the current year, the tribunal found that this was also open quotation, not supported by any logic, unquote. It was in those circumstances that the matter was remanded to the ACST open quotation. Just take the last 6 lines to make fresh assessment as per our rubber observation, that is the age of so and so, up to end. Paragraph. While admitting this revision petition on 5th February 2013, the following question of law is framed for consideration. And the impugned order of the tribunal state. Reproduce the question. Paragraph. This court has heard submissions of Mr. Siddharth Rai, learned senior counsel for the petitioner, and Mr. S.S. Padi, learned counsel for ASC for the department. Paragraph. Mr. Rai stated, submitted that the remand by the tribunal of the matter to the ACST was unnecessary, since all the materials were already available before the tribunal. Full stop. Relying on the decision in Shiksha O Anusandhan versus Commissioner of Income Tax, 2011 36112 bracket Orissa, contended that once all the materials were available on record, the tribunal should have disposed of the case on merits by taking such materials into consideration. Paragraph. In the present case, the court finds that the tribunal noted 2 things, namely that there was no logic or materials to support the decision of the ACST to fix the yield percentage of rice bran oil for the petitioner at 20%, for both the periods under consideration, that is 2005-06 and the current year. Full stop. Equally, the tribunal also found that the petitioner's own claim that the yield was 14.44% and sorry, 16.10% and 14.44% for the two periods in question was also not supported by any logic or scientific material.
May I submit here, my lords?
Paragraph. Although counsel the petitioner contends that the petitioner did place on record
Yes.
all the materials in its possession, it is plain that the department had not placed any material on record in support of its contention. Full stop. In the circumstances requiring the ACST to undertake the exercise afresh after permitting the materials in support of either case to come on record appears to be the correct course of action to adopt as far as the tribunal was concerned. Full stop. This was an exercise to determine facts which were not already available and which were required to be examined before arriving at a decision on the claim of the SSC regarding the percentage of yield of rice bran oil. The court is unable to find any error having been committed by the tribunal in that regard. Consequently, the question is framed as answered in favor of the department and against the SSC. In other words, the impugned order of the tribunal is not interfered with. It is clarified that the assessing authority, that is ACST, will approach the entire issue afresh, uninfluenced by the earlier decision taken by the ACST or observations on merits by the tribunal.
May I submit, my lords, one...
The exercise be completed by the ACST within a period of 4 months from today.
May I submit, my lords, with your kind permission?
Yes.
Now, since your lordship is again remanding...
We are not remanding, sir.
No,
It's not interfering. That's it.
Interfering, yes, exactly. I'm sorry. Then, my lords, what I pray, my lords, the department also should bring materials.
Yes.
That also the observation may be made.
It's already there, sir. It's already there. The remand is only for both for you to place your materials.
Then the department, the tribunal, what the tribunal did to ask the remand, they remanded the matter to determine the yield. Now, my lords, the department may also bring evidence on record to disprove my claim and also give reasonable opportunity to.
So you will be again before the next authority if all this doesn't happen. Well, we don't want to foreclose any of your grounds.
Now, at least by your lordship,
less said the better.
This
All right.
Lordship's order has perceived. That's good.
All right.
List item number 58.
May I please?
Yes.
My lords, the petitioner manufactures and sells PVC pipes, my lords.
Yes.
My lords, dispute regarding the rate of tax, my lords.
Yes.
My lords, in the red chat under the OST Act, there is a specific entry for the PVC pipes at the rate of 8%. I have paid at the rate of 8%, my lords. There is a proviso there that provided the materials, raw materials, has suffered Orissa cell tax, my lords. But here in this case, my lords, some of the raw materials is purchased within state and some out of the state, my lords. So, my lords, alternatively, there is another entry regarding plastic goods, my lords. The PVC pipes, ordinarily commonly known as That is also at the rate of 8%. But what they have done, they have charged at a residuary clause, my lords, 12%. This is this issue.
Short point.
My lords, kindly see entry 140.
No question has yet been framed, sir.
My lords.
You were not heard.
My lords, it was ex parte order before the tribunal.
Let it go back, sir. It appears that you say admit the following question of law is framed for consideration. Could the petitioner have been given one more opportunity of appearing before the tribunal in the appeal, which was apparently decided ex parte by the impugned order? Question mark. Paragraph. The present petition challenges an order dated 18 January 2010 passed by the Orissa Sales Tax Tribunal conducted dismissing the petitioner SSC's second appeal number 2235 of 2004-05, which was in turn directed against an order dated 17th August 2004 of the Assistant Commissioner of Sales Tax, ACST, for the year 2001-02, confirming the extra demand raised to the sales tax officer (STU) in proceedings under section 12(4) of the Orissa Sales Tax Act 1947. Paragraph. Although the petitioner urges the court to consider the question whether the department is justified in subjecting the PVC pipes produced by the petitioner to tax at 12% under the residual entry and not under the entry (140), is it?
140 is for PVC pipes.
Either under entry 140 or what is class
136. Alternatively 136.
Or alternatively entry 136 of the rate chart appended in list C of the OST Act. The court does not propose to examine that question in the present petition, since the court is of the view that the petitioner ought to have been given one more opportunity to present its case before the tribunal. Stop. It is noticed that the impugned order was passed by the tribunal in the absence of the SSC, and it is but fair that the SSC should be given an opportunity of presenting its appeal once again before the tribunal. Paragraph. Consequently, while answering the question in the affirmative in favor of the SSC and against the department, the court sets aside the impugned order of the tribunal on the above short ground and remands essay number 2235 of 2004-05 to the file of the tribunal for a fresh hearing in accordance with law. The aforementioned appeal will be listed before the tribunal on 24th August 2022, on which date the petitioner through its authorized representative shall remain present before the tribunal. A copy of this order be sent to the tribunal forthwith. The court clarifies it has not expressed any view on merits.
Special Wiki List item 59.
Not pressed. Not permitted to withdraw.
Counsel, the petitioner seeks leave to withdraw this petition. Dismiss this withdrawal.
Special Wiki List item 61.
Dear my lord, the question relates to entry tax on imported goods, and that has been settled well by the judgment of the Constitution Bench judgment, my lord.
That para 123.
My lord.
Yes, sir. What do you say? Covered.
No, no.
This petition by the state is directed against the impugned order dated 22nd September 2012 passed by the tribunal, Orissa Sales Tax Tribunal, bracket tribunal, allowing the SSC's essay number 34, bracket ET of 2011-12. Stop. The questions ought to be urged by the state in the present petition is whether entry tax under the Orissa Entry Tax Act 1999, bracket OET Act, is leviable on the purchase value of the scheduled goods brought from outside the territory of India and into the local area for the purposes of use, consumption, and sale. Question mark. Having heard learned counsel for the parties, the court finds that the question is no longer res integra. The Supreme Court, as in State of Kerala versus Father William Fernandez, 2017 SEC Online SC 1291, answered this very question in favor of the department and against the SSC. Which is this para of this judgment?
Right is the last.
In para 146, bracket 1, it was concluded as under. Let's reproduce a conclusion. That you matter the question. The revision petition is disposed of labor outcomes. And the impugned order of the tribunal is set aside.
Special list item 62. Item 62.
Well, 62, the amount is disputed 25,360.
All right. In view of the insubstantial tax effect, the question of law is left open for decision some other appropriate case.
No, my lord, in fact, this question has already been answered by your lordship, holding that the penalty under section 42(5) is automatic. There is no discretion left to the assessing
Oh, I
authority.
see.
In the last week, your lordship has decided.
Or in that case, you just say you
My
know
lord.
the decision.
My lord, here is the case because of the retrospective cancellation of the eligibility certificate by the industry department, this thing has happened.
But penalty has been held to be automatic. There is no
Right.
discretion left.
All right. This petition by the SSC questions an order dated 18th February 2011 passed by the Orissa Sales Tax Tribunal in essay number 2 bracket VAT. Sorry, in essay number 2 bracket VAT of 2010-11 for the period 1st April 2005 to 31/12/2008. Paragraph. The questions ought to be urged by the SSC for consideration. Is whether the orders of the STO, the ACST, sorry, orders passed by the Assistant Commissioner of Sales Tax and the dated 25th February 2009 as confirmed by the Commissioner of Commercial Taxes in the order dated 30th December 2009 in the appeal by the SSC. Confirming the penalty amount was justified. Paragraph. In view of the decision of this court dated 5th July 2022 in STREV number 69 of 2012, bracket State of Orissa versus Mrs. Chandrakanta Jayantilal, the above question is answered in the negative, that is against the SSC in favor of the department, thus upholding the penalty levied in terms of section 42 bracket 5 of the Overt Act. The petition is accordingly dismissed.
Special legal list item 63.
My lord, advocate for the opposite party, Mr. Jyoti Patnaik, is suffering from
None appears
pharyngitis,
to the petitioner. Dismissal.
and I pray for adjournment.
Special legal list item number 64.
None appears. Dismissal not possible.
Special legal item 65.
None appears. Dismissal not possible.
Special weekly item 66.
None appears. Dismissal not possible.
Item number 67.
I'm for the investment, I'm for the bank.
All right. None appears for the petition. Dismissal not possible. You know, the interim order.
State Bank of
Special weekly list item 68.
67. 67. My lord, I am for the. I filed this case.
67, there is no ban. Wrong.
67.
67 is his case.
My case, Your Lordship. Oh. 67, my lord. If the petitioner has challenged the action of the opposite party in not disposing of the application of the petitioner, and on the other hand, is threatening to evict the petitioner without following the procedures of law, Your Lordship. What has happened? I had.
What is the challenge, sir? Come to the prayer.
Prayer, Your Lordship. It is therefore respectfully prayed that this honorable court be pleased to admit the writ petition, enter records from the office of the Tahsildar Lathikata be called for, and the opposite parties be noticed to show cause as to why the lease in question will not be granted in favor of the petitioner, and if the opposite parties fail to show cause or shown insufficient cause, necessary order direction be passed to grant lease in favor of the petitioner after observing all formalities as required.
What is the application you filed?
Well, I am in possession.
No, what is the application you have filed?
To grant the lease in my favor, Lordship.
No, when did you file the application? Where is that application?
Lord, he is in unauthorized occupation. Encroachment case was initiated. Thereafter, he filed an application. This land may be, and
But
now
you have not
coming-
disposed it of.
Now coming to court, that may be disposed of first. So there is a procedure for your application for grant of lease will be considered in accordance with
No,
law.
when? Accordance to law, when is the question? This is 2013, it's been pending, sir. You say if the only order that can be passed, having heard learned counsel of the parties, it is directed that if it has not yet been disposed of, the petitioner's application dated 2/8/2013 stated to be pending for seeking allotment of the lease of the land in question in his favor, stated to be pending before the Tahsildar. Lathikata will be disposed of by that authority after hearing the petitioner within a period of 3 months from today. The court clarifies it is not expressed any view on matters. The petition is disposed.
Special
If it is
list
not
item number
disposed.
68.
None appears dismissal not possible.
Item number 69.
None appears dismissal.
Item number 70.
On behalf of Mr. Pal, the matter has been infructuous. I may be permitted to.
The petition has been rendered infructuous. It is disposed of.
Special legal list item 71.
None appears dismissal not possible.
Special legal list item 72.
72, Your Lordship. Special 72, Your Lordship. I have taken a term loan from the OSFC. And Your Lordship, certain dues were arranged.
Sir, what you've drafted a one-page prayer. You must be given a special award for that, sir. Such a long prayer.
Well, I'm not.
Takes a lot of effort to draft such a long prayer.
Also to read. Well, only my prayer is I have applied for the OTS in the 2007, floated by the OSFC. That OTS application has been accepted. So I am agreed with the OTS application. In terms of the OTS application itself, I filed an appeal. Your Lordship, page 28 of the brief, Your Lordship, just have a glance. Page 28 of the
Who's
brief.
appearing for OSFC?
Yes, my lord, I am appearing for those.
What are your instructions, sir?
My lord, he has applied for OTS, my lord. Now he is saying that 11 OTS is too high. We are now the 2011 OTS is continuing till today, my lord.
All right. If you want to be considered under 2011, we can pass an order, sir.
Yes,
page,
yes, sir.
my lord, page 28, your lordship, my lord, page 28, I have referred an appeal. In terms of that OTS scheme, your lordship, clause 13 of the OTS scheme. So I have filed an appeal before the managing director, which authorizes, your lordship,
Which OTS scheme, sir?
OTS scheme 2007, because
So that's the whole problem, sir. You will be considered under OTS 2011. I have already enjoyed a stay for how many years now? 13 years.
No, it was not stayed, your lordship. It was not stayed, your lordship.
There is no cause of action against you, sir, since 2013. 2000.
So, my lord, on 9/2/2022, your lordship has vacated the.
My lord has vacated that stay order.
Only after 13 years.
And in that, on another writ petition, there was no stay, your lordship.
There was,
no
sir.
stay.
In the writ petition, there was a stay passed on 24th September 2009.
Yes, my lord.
My lord, my lord. That was
Vacated on 9/2/22.
vacated by your lordship.
When?
That on date 8.
22.
22.
9/2/22.
13 years, there was a stay, and you keep on saying no, no, no. I don't know for what.
Another writ petition, there
They're
was
just
no
reading from our own orders and telling you there was a stay for 13 years, and you keep
Yes.
saying no.
No, my lord, that is not. That I am not
Even
saying.
now, you're saying no.
No, I am not saying that your lordship has not passed this stay order. I am not saying that no, your lordship.
You're
It is not my
remarkable,
intent.
sir. You're remarkable.
It is not my intent, your lordship. It is not my intent.
Prayer is to
Sir,
finalize
if you
the
want to
account.
be considered under OTS 2007, we can pass an order. Otherwise, we're not inclined to interfere. As simple as that.
My lord, 2007, your lordship, the appeal may be disposed of.
No, that is not the prayer.
Appeal will be not disposed of, sir. It's an appeal under 2005 OTS that is
2007.
gone. Now you have OTS 2011. If you want, case can be considered under that.
My lord, that.
Counsel, the petitioner is agreeable that the petitioner's case can be considered under OTS 2011 by the OSFC. Stop. In that view of the matter, a limited direction is issued to the OSFC to consider the petitioner's prayer in terms of OTS 2011, preferably after hearing the petitioner, within a period of 3 months, and communicate such decision to the petitioner.
If such an application is filed.
No, that appeal is filed itself. You treat it as that application. You say for this purpose, the appeal already stated have been filed by the petitioner.
Yes.
He treated as an application under OTS 2011. All right.
Well,
Obliged.
second writ petition is also the same, your lordship. In that application, your lordship, the appeal is at page 32.
You say in view of the order passed today in 13692 of 2009, this petition is disposed of in the same terms. All right.
Special weekly list item 73.
Obliged.
None appears dismissal not possible.
Special weekly list item 74.
None appears dismissal not possible.
74 is for correction.
This last line of the court's order is corrected to read as STREB. Right. Same, 75 also.
Special weekly list item 76. Special weekly list item number 76.
None appears dismissal not possible.
Item number 77.
Pray for liberty to file fresh application if cause of action.
No, nothing, sir. 2013 matter.
Cause of action survives floodship. If cause of action survives floodship, you can file.
No, then you file separately, sir. That's okay. Nobody's going to prevent you. There's a fresh error. Counsel to the petitioner points out that the petition has been rendered defectuous. It is disposed of this.
Special weekly list item 78.
None appears dismissal not possible.
Special weekly item 79.
Item number 79. The villagers are before this honorable court for construction of an underpass within their local village limit. Because Annexure 2 will reveal that the middle portion of the village has been acquired. Vast chunk of land lying to the south and their residential area is lying.
Any idea whether this representation was received by them or not? There's no proof of that.
Council appearing for the railway had taken instruction on 10/12/2013.
Where is that? Where is the council for the railways now?
My lord,
You call him, sir. We'll pass it over. Right. Please call him. Please call the railway council.
Special weekly item 80.
May I please, my lord? 76, my lord, I'm outside.
Can you just remove your mask, sir? You are inaudible.
My lord, item 76, your lord, sir.
So you can't come suddenly. We are now in item
My lord, 76.
79.
76, my lord. I'm outside, just standing.
Sir, nothing will happen. You just wait till the board is over. We'll definitely hear you. Please take your breath, sit down, relax.
my lord,
All right.
79(2), it's time to file counter, my lord. I am for the railway, my lord.
Yes.
I have obtained instruction and they have sent Parawage comment. My lord, 2 is time to.
No. Just show us the Parawest comment. This is a 2012 matter, sir. 13. 9 years old. Show us the Parawest comment.
I have.
You read from the Parawest comment. He wants an underpass. What is your railway saying about that underpass? That's all.
My lord, railway saying, my lord,
You're now reading it. All right, pass over. Sir, kindly sit down, read it carefully and tell us. All right, pass over.
Item number 80.
None appears
I'm
dismissed.
for the opposite party, my lord. I am for the opposite party.
All right. None appears dismissed and opposite.
Special weekly list item 81.
81 May His Lordship and virtual movementship. It is the eviction of opposite party from the encroachment land and construction of the government landmanship. That is my representation which is pending before the annex before the opposite party of 5 miles, which is annexed in Annex 4 miles.
All right. You say the representation of the opposite party or representation in Annex 4 made by the petitioners be examined by the opposite party number 5.
5.
Asildar Rajnagar. And after issuing
Rajnagar.
the petitioner as well as opposite party number 8. And after giving them a hearing, a reasoned order shall be passed thereon not later than 2nd September 2022. And the order shall be made available to the parties not later than 9th September 2022. The court clarifies it is not expressed in any matter.
Special weekly item 82.
Here, this matter relates to effective implementation of noise rules as well as ban of Chinese-made firecrackers.
Sir, there is an NGT in Calcutta. Please go there.
Yes, my lord. My lord, now I want to humbly submit, my lord. In this regard, Honorable Apex Court had decided the matters. I am relying
You are
upon
happy
that,
on
my
that?
lord. In that line.
All right. See, in light of the decision of the
Yes,
Supreme
ma'am.
Court of India,
Three judgments I am referring to.
the petitioner who appears in person states that the prayers made by him already stand covered by the decisions of the Supreme Court of India in noise pollution bracket 5 versus Union of India 2005 5 SCC 733 and forum. How can be prevention of environment, sir? Prevention of environmental pollution. Pollution. Right? No. AR 2006 SC 348. Therefore, he does not wish to continue this petition any longer. It is disposed of as such.
Obliged, my lord.
Special weekly list item number 83.
None appears dismissed or not prosecuted.
Item number 84.
None appears dismissed or not prosecuted.
Item number 85.
85, my lord, is a PIL matter, my lord. The petitioner challenged the illegal action of the observer 3, my lord. And kind of glance the order number 4 dated 11/3/2016, my lord. Order number 4. The petitioner
You can
in
approach the
public
NGT, sir,
interest.
for all this. You say, leaving it open to the petitioner, if the cause of action survives, to approach the National Green Tribunal in accordance with law, the petition is disposed of. All right.
Special weekly list item 86.
This is 85.
86.
85.
Item number 86.
86. May I please, Your Lord? Well, it is a public interest litigation where, my lord, the hundreds of people of Baripada town, they have made a representation before the executive officer Baripada municipality. Instead of saying that, my lord, the proposed vending zone in both sides of the road, in a busy road, may not be constructed. For that purpose, though, my lord, several places are there available, but instead of placing that at the instance of the then councillor, my lord,
You have to give them all. Who are those people, sir?
My lord,
Who are the people who have erected all these shops and constructions? Who are they?
my lord, the construction is being taken by the executive officer Baripada municipality.
No. If we allow your writ petition, will something happen to somebody or nobody will be affected?
No, my lord, the general people will be affected because, my lord, on the both sides of the road, in a busy road, my lord, they are making the vending zone, my lord.
Sir, whoever has put up shops, will they be affected if we pass orders?
No, my lord, in order to rehabilitate those persons who are doing the improvised shops, that vending zone is being, the decision has been taken to construction of the vending zone, my lord.
Sir, this is a 2015. I'm not able to understand what you are trying to argue.
Yes, ma'am.
This is a 2015 petition. We are in 2022.
Yes, my lord.
What is the decision you are challenging?
My lord, I am challenging, my lord, the inaction of the opposite party number 4. The opposite party number 6, my lord, in not considering our grievance, my lord. But we have made a prayer.
Prayer for what?
A prayer, my lord, not to construct the vending zone in both sides of the road. It is a busy road, my lord.
Have they already constructed, sir? We are in
No,
2022.
no construction has been undertaken, madam.
So if there is any
after
fresh
receipt
cause of
of
action, you make a
notice,
fresh representation.
But
Council
after
with the
receipt
petitioner
of
states
notice
that in the
from
last 7 years, the proposed vending zone has not been erected.
Yes.
If any fresh cause of action survives, it will be open to the petitioners to make a fresh representation to the authorities concerned, disposed of. All right.
Special weekly list item 87.
But till then, my lord, status quo at least, my lord.
What is status quo? Nothing is happening there. What is status quo?
Right. After receipt of notice, they start the construction.
All right.
Now, my lord, after disposal, they may start again, my lord.
Then you'll be alert, sir. Yes.
Item 87.
87, may I pray for an adjournment, my lord? Because Mr. S.K. Mahanti is ill, my lord.
No, what is the matter about, sir? You tell us.
He has instructed me to only take.
He may say so many. So you tell us what the matter is. You have the paper book or you don't have?
The
You just walked into the court.
Encroachment, eviction of unauthorized person.
I see.
The encroachers are not parties. Sorry.
And that representation also, it's not clear. So you say, alleging that there is some encroachment on public land. The present petition has been filed, seeking directions to the opposite parties. Paragraph, how the court finds that the encroachers themselves have not been named or been made parties to the present petition. Permitting the petitioners to file. No, I think there is that Swarna Priya.
One of the opposite party number 5.
That take the last line off. The direction is issued to the opposite party number.
Tahsildar Ersaman, opposite party number 4.
3. Tahsildar Erasma. To examine the petitioner's representation dated 9/12/2013, bracket annexure 1. And after issuing notice to the petitioners as well as opposite party number 4, pass a reasoned and giving them hearing to pass a reasoned order not later than 19 September 2022 and make the order available to the parties not later than 26 September 2022. Court clarifies it was not expressed any on the matter.
Special weekly list item number 88.
None of this is numbers.
Special weekly item 89.
My lord, Karthik Jana is present for opposite party.
All right.
CGC.
All right. None appears dismissed or not.
Special weekly list item number 90.
May I please, Your Lordship? Lordship, may I be permitted to place the matter on behalf of Mr. Anurag Pati?
Yes.
My lord, this is a PIL filed with reference to the allotment of lands. My lord, the land is a scarce resource and its allotment should not be arbitrary. This is
You
the
can go to the
observation.
Lokayukt, sir, for all this. You can go to the Lokayukt, permitting the petitioner to approach the Lokayukt in accordance with law regarding the issues raised in the present petition. The petition is disclosed.
Special vehicle list passed or matter.
May I pardon, my lord? Item 76, my lord. It is a case lordship has already
So
directed.
we'll call it out, sir. Let the passover get over.
Item number 7.
May I please lordship matters? 7 matters. I don't have the records with me, but I've gone through my lord's records. That writ appeal matters. AHO.
Delay, sir. First of all, delay. How much is the period of delay?
960 days.
You said there's a delay of 960 days in filing the appeal.
Petitioner matters at the time of filing the writ application also was 52 years old. Now she must be 76.
Anyway, since the delay is not satisfactorily explained, MC number 19 of 2003 is dismissed. Consequently, the writ appeal is dismissed. Right.
Passed or matter. Item number 16.
I beg pardon for not remaining present, my lord. In this writ petition, my lord, the petitioner had availed a loan, my lord, for purchase of a vehicle, my lord. But the loan could not be repaid. A notice was issued to the petitioner, Annexure 1. Lordship may kindly see Annexure 1, lord. Page 5. Lord, the notice indicates towards the bottom, my lord, the petitioner was required to clear up the dues of rupees 1,72,000, my lord, by 30th/3/2011. But this notice was issued on 23/3/2011 and it was received by the petitioner on 29th/3/2011. Lordship sees towards the bottom the endorsement. Lord, on 30th, my lord, after selling, my lord, valuable properties of the petitioner approached the bank to get back the vehicle and pay the loan amount. But he could ascertain, my lord, that the vehicle had already been sold, my lord. But to this issue, my lord, before the notice period, the vehicle could be sold. But counter affidavit has been filed. There is no denial to that effect also. In fact, nothing has been stated.
There's no interim order here, sir. So the tractor has been sold now.
I bow down, Lord, to that.
Now what needs to be done now? Tell us. Nothing needs to be done now.
The action was arbitrary, my lord. That is the only point which I beg to place before my lord, my lord.
That's all. Say it is seen that the tractor in question has already been sold. Despite repeated efforts of the court and the permanent and continuous Lokadala, no settlement has been able to be arrived at. So, in the context, in the circumstances, the court is not inclined to interfere at this stage. Full stop. The petition is disposed of.
May I pray, my lord, one more thing, my lord?
Yes.
Since the action was arbitrary, my lord, may I pray, my lord, I may file an application for compensation. My lordship may permit
It
me.
will be open to this petitioner to seek other appropriate remedies for recovery of damages.
Not delay to that effect, lordship.
That we don't know, sir. All right.
Special vehicle list passed
As
or
well.
matter. Item number 17. Passed or matter 17.
In fact, my lord, opposite part number 1 was alerted canteen number 1 by the cell authorities. And by virtue of his power of attorney, I am continuing to run that canteen number 1. And till now, I am till the order passed by this honorable court. My lord, he is from the cell, my lord.
What's your instruction?
In fact, the license was granted to opposite part number 1. And there is a condition in the order granting the license that they will not sublet the premises to any other person. By violating that condition, he sublet to the present petitioner. So therefore, we cancel the license. Thereafter, the PP proceeding was initiated for eviction. Now, on the basis of a power of attorney, he has approached your lordship that the license should be granted in his favor. That is the
Under what conditions, sir? What is your right to get the license in your favor? As it is, you violated the condition against subletting.
that the condition is at page 47. Sub-paragraph, that is condition number 8, as page 47 of the brief.
Right. That's the end of the matter, sir.
Till
The
now, I have-
petitioner admittedly is a sublessee and is under opposite party number 1, was granted a license by sale Rourkela
Yes, my lord.
to run a canteen in the factory premises. So, clause 8 of the condition of license.
Annexure 16, the license was granted on 11/6/99.
Specifically prohibited the licensee from transferring the license or part with it, or part with possession of the premises, or any part thereof, in any form, open petition, or sublet the premises without the written permission of the licensor, unquote. So despite the above clause, without permission of sale, that is the licensor, opposite party number 1 sublet the premises in question to the present petitioner. Paragraph, the petitioners, when faced with eviction, the petitioner approached this court for directions to sale to issue the license in his favor in respect of the aforementioned canteen, while directing notice to issue the present petition on September 2011, this court permitted the petitioner to continue as such. So for the last nearly 11 years, he has accordingly been continuing in canteen number 1, paragraph. Counsel, the petitioner has no explanation to offer as to how the court can possibly issue a mandamus to the opposite party to grant him a license in his favor when he has clearly been sublet the canteen by the original licensee in violation of the conditions of license. Paragraph, there is no merit in the present petition. It is dismissed as such. The interim order.
Past door matter item number 41.
May I please, your lords.
Yes, the other side, sir.
The other side, Mr. BP Tripathi appear for the OP, my lord.
Yes. Yes, Mr. Tripathi. Yes, Mr. Tripathi.
Yes, ma'am.
He had already retired by the time this reinstatement order was passed.
Yes, ma'am.
So are you agreeable to pay him some compensation?
My lord, in the meantime, on 26th June 2012, he has already taken the money, my lord. 1
He has
lakh
taken
sum.
what? Yes,
All benefits and monetary benefits, whatever the amount, he has already received on 26th June 2012, my lord.
What was the benefit, sir?
Like gratuity and all, he has already received. If your lordship permit me 2 days time, I'll file affidavit to that effect, my lord, along with the document which he has received.
We only receive 1,07,000 or 8,000 only, my lord.
9,426.
That's okay, then why should we do that? 1 lakh?
1,09,460, my lord.
The grievance of the petitioner, workman, against the impugned award dated 25th February 2012 of the Labour Court in ID case number 22 of 2003 is that only the relief of reinstatement in service was granted without any compensation. After finding the termination of the services of the petitioner to be by the opposite party number 2 management to be illegal. It is pointed out that the petitioner superannuated reached the age of superannuation on 16th.
My lord.
On which date?
7th February 2012.
7th February 2012. And therefore, by the time the award was passed, and therefore the relief granted became illusory. Paragraph. It is accordingly prayed that this court should direct the opposite party number 2 management to pay him some compensation. Paragraph. Mr. Tripathi, Learned Counsel, appearing to the management, points out that after, nearly 4 months after the award, on what date, sir?
26 June 2012.
26 June 2012, the workman accepted all the retirement benefits, including gratuity, in the total sum of rupees 1 lakh.
1,09,460 minors.
9,469 without any protest or demo.
460 minors.
460 without any protest or demo. This is unable to be disputed by counsel for the work. That view of the matter, no further directions are called for. The petition is disposed of.
My lord, so lordship kindly enhance the matter. They only said to bank account they have been sent.
So you should,
We have given objection, my lord.
Where is the objection, sir?
They have sent through the bank account, but without any intimating you, my lord. Intimating us, my lord.
On his request, my lord.
This is my.
On his request, it was paid, my lord.
Right.
See, service in for 8 years, my lord, and after 12 years, the award has passed, my lord. In the Law and Labor Code, clearly categorically state that there is no fault of the workman, my lord.
All right.
More amount may be given, my lord.
Yes.
Special weekly list passed over matter. Item number 70.
I may be pardoned to mention item number 40.
Yes.
76.
76.
We'll finish this and then we'll.
My lord, in this case is case of the atrocity, my lord, and the ST peoples are victims. Lordship passed the order, last order, my lord, 29, 2021. That is the last order, my direction was given.
It's before that, my lord, if I may.
For early disposal of the cases and the further affidavit by the for payment of compensation, etc.
Correct.
My lords,
This suddenly it wasn't listed thereafter, which is what was wondering. Yes. What about that order dated 22nd September? And the collector was to file a further affidavit. What happened?
yes, my lords, there is an affidavit dated 27th of October, my lords, which is pursuant to my lord's order dated 2nd of August, where my lords, 9 victims out of the 40 odd victims were not paid compensation. Therefore, my lords, we have filed an affidavit in October 2021, where my lords, if my lords may see, it is 27th of October 2021.
Right.
Para 2 onwards.
Yes.
Para 2 details that 5 numbers of victims, namely so and so, the names are given. They have, my lords, been paid 60,000 because, my lords, as per the 2011 rules, 50% has to be given upfront and thereafter, my lords.
So what's the progress in the criminal case, sir?
There's progress in the with regard to, my lords, that's the other leg. As for that, my lords, I have to take
yes, you better take
updated.
We want to make sure that it's taken to a logical end, sir. You see, counsel for the state needs some more time to ascertain the present status of the criminal case and file an affidavit of the collector in that regard. Collector or the superintendent of police of the concerned district in that regard. The affidavit will be filed positively before the next date. List on 7th September.
Well, that's only one aspect, my lords, with regard to this compensation, since that was ordered in August 2021 and pursuant to that, this affidavit has been filed. Because that compensation bit may be mentioned, that the compensation with
No, the 50% has to be paid on conviction, sir.
Please, my lords, please.
So you better make sure they get convicted so that you can pay the remaining 50%.
Please.
Yes.
Great. Passed over matter, item number 79.
My lord, so far as instruction of the opposite party 1 and 2 is, my lord, the land have already been acquired by the opposite party number 3, that is Utkala Almunia International Limited, my lord. The track is using for their business, my lord. So the railway is not authority to construct bypass, my lord.
No. The railway has to go ask for land from somebody else to construct the bypass. State will have some other land, sir.
My lord.
Land has to be acquired for constructing a bypass, correct?
Yes, my lord.
So the state will find the land. Have you asked the state to find out some other land for constructing the bypass?
Railway is making construction for the opposite party number 3. The railway administration is making construction of a railway track to the opposite party number 3 factory unit.
All right.
So the acquired land is in the middle of the village. So there is no provision to pass through the railway track.
So what is your instruction on that underpass, sir?
The petition.
My lord, I may be permitted to 2 weeks time so far.
Council of the Railways wants some more time to ascertain the instructions of the railways on the plea of the petitioner villagers for construction of an underpass, since the proposed railway line is running across the village.
In the middle portion of their revenue village.
All right. At his request list on 5th September, the affidavit possibly be filed of the railways before that date.
Last one matter, item number 40.
No, there was one more person who was panting and puffing and what is this case number?
Mayor, the policy claimed by the mediclaim policy claimed by the petitioner as reported by the insurance company, and after order of ombudsman, I prefer this application.
Let's read the ombudsman's order.
The ombudsman order
You did not disclose that you were suffering from diabetes, sir.
My lord, actually that was not diabetes. The patient was admitted for the appendicite pain, and during operation, she was suffered from the septicemia.
No.
And
She was suffering from diabetes since 2007.
diabetes is one of the causes.
2007 onwards, she was suffering from diabetes. That's the finding.
I am not disputing, man. Diabetes may be one of the cause, but she died.
All these insurance policies, if you do not disclose an existing medical problem, then you will be disqualified from claiming that.
But when I fill up the form, I put my no against the diabetes column. They have not medically examined my that was accepted. My policy was accepted.
No, unless you say yes, or you have to indicate that, sir. You are aware of your diabetes, you have to indicate. How will the other doctor know? How will anyone else know unless you disclose?
The cause of death is septicemia. I have
no. It gets aggravated, sir. All of this, when you are diabetic, then you become vulnerable. Any problem gets aggravated because of that.
I'm admitting, man. Nowadays, diabetes is a common. Diabetes is a
please.
hormonal disorder. It's not a disease.
No, sir. What we can't presume everybody has got diabetes.
My lord, my humble submission is the Lord and Ombudsman illegally disposed of my application. That is my have a glance on.
Sir, you answered this question. This is the only thing that the Ombudsman has pointed out.
Ombudsman pointed and disposed of the award, and the section is clearly says that award should be passed.
Nowhere it is clear mentioned that nil award. Nowhere it is mentioned that always ombudsman should pass an award with amount. That section enters.
Irrespective of whether you're entitled or not.
Silent about the
No, so irrespective whether you're entitled or not, ombudsman should give you some money.
That apart, my lord, he has not given me chance to file rejoinder, and he has not supplied the counter, copy of the counter. He has not given chance to adduce my evidence. Entire ombudsman order is totally silent. Have a glance. Section 14, 1 and 2 of the redressal of that I'm placing, my lord. Section 14 of redressal of public grievance rules. The ombudsman to act fairly and equitably. The ombudsman may, if it deems fit, adopt a procedure other than mentioned in sub-rule 1 and 2 of the 13 for dealing with the claim. That is under CPC. He has to follow the provision of CPC to adduce evidence to that they have not done. That about, my lord. Section 14 of the award, that says award, where a complaint is not settled by agreement under rule 15, the ombudsman shall pass an award which is he thinks fair in facts and circumstances of the claim. An award shall be in writing and state the amount awarded to the complainant, provided that the ombudsman shall not award any compensation in excess of which necessary to cover the loss of suffered by the complainant as direct consequence of the insured peril. That means when always amount is mentioned, that upon my ombudsman shall pass an award within a period of 3 months from the receipt of the complaint. But here, my lord, the ombudsman disposed of my application after 6 months, my lord. That is clear provision is ombudsman should dispose of the application within 3 months from the receipt of the complaint. Next, my lord. Section 16.3 clearly says that 3 months and CPC should be followed. That Insurance Act, redressal of public grievance rule.
On merits, you have nothing to say.
Well, I have collected so many decisions where the suppression is there. The Honorable Supreme Court has also held that the suppression in case of diabetes. I have collected number of decisions, my lord. These are our High Court also observed in 91, and so many decisions are only on the basis their diabetes ground.
Only one copy you have?
Sorry.
All right. We'll deal with all these judgments. The petition is dismissed. All right. Continue after lunch.
Weekly list, item number 19, matter fixed for 2 p.m.
So any change after that judgment of the Supreme Court?
No, my lords. After the judgment of the Supreme Court, there is no change. What I pray to your lordships, lordship may take each individual matter. That will be, of course, it is covered. Most of the cases are covered by the judgment in rendered in Union of India versus Ashish Kumar Agarwala.
That's what.
But still, then, my lords, para 4, para 4 to para 8 of the judgment says that so far as the differences are concerned, that is time limit and other things are concerned, as well as under the first proviso to section 149, that is left open. So proviso to 149 says that notices which could not have been issued due to time limit, say 6 years or 4 years, then the notice under the new act also could not be sustained. And that is why what I am humbly praying, your lordship may take each.
There will be one whole batch of cases which now do not survive because of the Supreme Court order.
Yes.
Which are those cases that
I am accepting, my lords. I am giving. Accepting the writ petitions. I am giving the list, my lords, along with the cover.
My lord, in the meantime,
Just a minute. Arre, ye kaun? Kindly wait.
So give us a copy of the Supreme Court order.
Instruction is
Yes.
important.
Instruction cannot override the statute or Supreme Court judgment. I've got one copy. Acha, ready, sir? If your lordship may permit me, एगुड़ा भी नहीं जा इधर नहीं हम भी क्या इधर साहब नाम इधर इधर हमको
So who's in your matters, the 5 writ petitions who's appearing from the department side?
Department side बाहर कर ले WBC number 38776 of 2021. Here, my lord, 6 years have passed.
No. Who's for the department?
Department just. I'll revert back to you. That's 38.
Instruction very important.
Okay. Body got appreciate. My lords, in the first matter, I think Mr. Satpathy is appearing. Assessment year is 14-15. I would have. Then 13-14, my lords. 33778 of 2021. Here, my lords, the notice has been issued in 38778 on 31st of March 2021. So it is covered by that judgment of my lords in Rubina Senapati that 6 years, that time limit under section 149 in the earlier act. Beyond 6 years you cannot. And 6 years is being time starts from 31st of March 2020. Now the notice in 38778 of 2021, your lordship will be pleased to see Annexure 1, page 13 and 14. Again another notice beyond time limit. Lordship may take up this 38778.
No, but who's appearing for the department?
Mr. Satpathy is appearing, my lords. 38778 and 38. आइए हम कोच पैसे
May I request your lordship? Lordship, kindly take up one by one because serially if lordship call, then it will be better to assist your lordship. If your lordship take up in this,
all right, let's start.
Yes.
Yes.
First item is what? Rashmi Motors.
Rashmi Motors, my lord, that is covered by Rashmi Motors, na? First time. Rashmi Motor is covered by Union of India versus Ashish Agrawal.
All right.
And the notice.
Normally it is for the assessment year 17-18 and notice and issue.
No, sir, it's covered.
Covered.
He says it's covered by the Supreme Court judgment.
After that instruction been.
There's two type of case. One is after 1/4/21 before 31st 3 to that. Both the notices have been two type of cases. Not one is prior to 31st March 21 and next one is after 1/4/21.
No,
yeah, after
Supreme Court covers only after 1/4.
Yes, sir.
Yes. Yes.
No, sir. Rashmi Motors is after 1/4.
Yes. It is on 30th of June 2021.
So it's covered by.
And this notice will go and they will proceed along with, in accordance with the law laid down by the Supreme Court. They have to issue a fresh notice under section 148A.
Let's go to instruction. Instruction very given.
Yes.
Ashish Agrawal judgment.
Yes.
Instruction.
We are looking at the instruction only, sir. Tell us which paragraph. Para 8.1, sir. The procedure is now laid down. Para 8.1.
8.1, yes. The extended reassessment notice are deemed to be so cause notice under clause B of section 148 of the Act.
in accordance with the judgment of the Honorable Supreme Court. Therefore, all requirement of new law prior to that show cause notice shall be deemed to have been complied with. The assessing officers shall exclude cases as per the clarification in paragraph 7(1) above within 30 days of 2nd June 2022. The assessing officers shall provide to the assessing in remaining cases the information and material relied upon the issuance of extended reassessment notice. Then the assessee has taken 2 weeks to reply as to why a notice under section 148 of
So
the
which is, this is for AY, which year?
Yes.
AY is assessment is 17-18 man.
17-18.
Just come to
17,
para
18.
6.2, sir. Para 6.2.
Yes. Based on the above, the extended reassessment notice are to be dealt with agenda 13, 14, 14, 15, 16. Fresh notice under section 148 of the
Next line, next paragraph.
Yes.
AY 16, 17, 17, 18.
Fresh notice under section 148 can be issued in these cases with the approval. Yes.
So you have to follow this. You say in Rashmi Motors, you say this court is informed that the present petition stands covered by the judgment dated. It is not still reported. This Ashish Agarwal.
Yes, ma'am.
Yes,
It's reported now.
May I
just give the reported.
Yeah.
2022 SEC.
It's reported in tax manual. May I just hand over
Yes,
the
yes,
copy?
yes.
I've given your lordship 2 copies.
Covered by the judgment of the Supreme Court in Union of India versus Ashish Agarwal, 2022. No, you can say 2022 444 ITR page 1. Mr. Chimanka has also placed before the court copy of the instruction number 1 of 2022 dated 11th May 2022 issued by the ITJ section of the CBDT on implementation of the above judgment of the Supreme Court. Paragraph. In view of the above judgment in Union of India versus Ashish Agarwal Supra, read with the instructions dated 11th May 2022, the impugn notice is set aside.
30th of June.
Subject to the revenue
2021
complying with the instructions dated 11th May 2020.
When the annexer want to be quashed and they have to give us a press notice.
Yeah, set aside and they'll follow this.
Yes,
Subject to their following.
Lordship may quash this notice.
Have you said set aside the same thing?
Yes.
All right. Next matter.
WPC 21046
1516 and 24/6/2021. 21046. Sri Salasar Casting Private Limited.
Yes, that is also covered by Salasar Casting. Itemized
WPC number 34.
Yes, ma'am. Here, my lords, assessment date is 15/16 and
date of notice.
Date of notice is 24th of June 2021, Annexer 1 at page 10.
So same.
Yes, ma'am. And may I submit one thing, else I filed an objection there too. Annexer 2, page 11.
6.2, you say. 0.2 bracket Roman small 2. In this, you'll say subject to compliance with para 6.2 bracket 1 of the circular dated 11th May. Again, it's squashed. The MP notice is squashed. Yeah, all that. So between ITJ section, CBDT, everything.
Annexer 1 to be set aside and
same thing.
WPC 21108 of 2021. Ashok Kumar Agarwal.
Next 21108.
Yes.
Ashok Kumar Agarwal.
Yes, ma'am. It's also covered by Ashish Kumar Agarwala. Date of notice is 28th of June 2021.
Yes.
And the assessment year is My lords, '16, '17.
The same. Point two.
WPC number 21119 of 2021. Arvind Kumar.
Arvind. Yes, my lords. This is also 17, 18 assessment year.
Point two.
And
bracket 2.
Date of notice is 21st of April 2021.
Right.
Page 14. Page 14, my lords.
Right.
Next WPC 21122 of 2021. Ramesh Kumar.
Dion. ସେଗୁଡା ନୁହଁ ମ ଖୋଜିବାକୁ ପାଇଲନି sorry my lords, I'm just giving. Yes,
my lord, same page. My lord, same page. WPC number 33883.
Just a minute, I'm just-
covered by decision.
I know, but let's go
Ramesh Kumar
one by one, sir. Otherwise,
So may pass over this.
so we can pass over this and go to the next one.
my lords, you can
WPC 21124 of 2021. Same Ashok Kumar Singh.
same Ashok Kumar Singh. Yes, my lords. Here 15, 16 is the assessment year.
Point 2 bracket 1.
And here, my lords, annexer, the notice is 12/4/2021, annexer 1 at page 10.
Right.
My lords. The assessment was completed under section 143(3). Annexer 2, lordship is covered.
Right.
Next WPC 21471 of 2021. Gajalakshmi business.
471.
471.
2147. Gajalakshmi, yes. Here, my lords, the notice is 94/2021.
Yes.
And the assessment date is 14/15.
Right.
14/15, but my lords, 6 years is expiring on 31st of March 2021.
Anyway, it's up to them, sir, what they want. All
My
right.
lords,
We are quashing it anyway, sir. So, sorry.
2021, my lords,
Next
they have issued the notice for the assessment year 14/15 and just 1 minute, my lords. Just lordship may kindly permit me. Only 1 second, my lords. Yes. Yeah, after 6 years, the notice.
Whatever, sir. It's 21471 you're dealing with, right?
Yes, 21471.
That same order we passed. Now call it next one.
21476 of 2021. Sunita Dalmia.
Sunita Dalmia. Here, my lords, Mr. Mahapatra is appearing. Siddharth Mahapatra. Here it is not applicable because the fact is, Bhargale and Sunita Dalmia olga itla. Lordship may kindly see Annexer 2. I went for Vishwas Se Vivad scheme. They have given me a certificate and an immunity is given under the Vishwas Se Vivad Act, that is clause 5. Under that clause 5, I am immune from any investigation. So this I'm giving the, Lordship, I have got the act also.
No, then he has to file a counter then.
You have to file a counter.
Yes,
No, counter they have filed and they have not dealt any of these point.
This method may be taken up next week, my lord. On this
All
code,
right.
my lord, I have
21476. You say list on 18 July. All right.
WPC
That's on 26th,
18th July.
18th July. I am giving the act, relevant act. Lordship, this may be kept on record, my lord.
WPC 21485 of 2021. YK Dalmia.
21 YK Dalmia. I think it's 14-15 my lord assessment year and notice is 942021. That is after 6 years.
All right.
WPC 21491 of 2021.
Yes. This assessment year 17-18. And the notice issued is on 21/6/2021. Squarely covered.
6.2 bracket 2.
Annex 1 to be set aside and
yeah.
WPC 21619 of 2021.
17-18, 25/6/21.
What? Guide. 17-18 assessment year. And the notice is at Annex 1, 25th of June, 2021. Page 12.
WPC 21631 of 2021. Utkal.
Yes, my lords. Notice is at Annexure 1, 942021. Assessment here is, my lords, 14-15. Assessment here is 14-15.
Bracket 1.
WPC 21891 of 2021. Sri Radhakrishna.
Sri Radhakrishna. Yeah. Radhakrishna, yes. 13-14 is the assessment year, my lords. And it is, my lords, it's not covered. It's already barred by limitation. And I am covered by the proviso to section 149, which could not have been issued, cannot be issued. That says. So therefore, 13-14 is this
The circular covers 13-14 also, sir.
My lords,
this circular they have issued covers 13-14
but
also.
your lordship knows circular cannot override the statute. The statute is under section 114, the proviso is which could not have been issued under the old act, cannot be issued now. That is the law, my lord.
No, now this judgment says it's
judgment. Lordship may kindly
under
say
the new act, sir.
Sub-para 4 to para 8. I've gone through the judgment and the judgment says that all the defenses are open. So my first defense is barred by limitation.
No, defenses are open, but whatever was issued under the old law shall be deemed to be show cause notices under the new law.
Correct. But my lords may kindly see the proviso to section 149, first proviso.
So now that will have to be argued in the Supreme Court because we are now covered by Ashish Agarwal. We have to
correct.
By this.
I bow down to what your lordship have said.
We are quashing that impugn notice and saying that the circular will apply. You can always challenge the new notice, sir. Yes. 21891. The annexure is quashed and they'll proceed in terms of the circular. Right.
WPC 21894.
May I also pray, my lords, in the reply, I can be given the liberty also to raise the question of limitation.
Sir, everything, all your defenses are left open. If they issue a new notice and you go to challenge, nobody can stop you from raising those defenses, sir.
My lords.
We are not foreclosing anything.
My lords.
Yes.
21894 of 2021.
Yes. Here, my lords, 15-16, notice is at Annexure 1, 942021.
Right, same order.
WPC 21895 of 2021.
985.
21985
of 2020.
21985. Notice is at Annexer 1 dated 25th of June 2021.
Right, same order.
WPC 21989 of 2021.
21989. Yes, my lord. 1617 is the assessment year. And notice is at Annexer 1, my lords, page 12, 30th of June 2021, covered by Assis.
Correct.
WPC 22270 of 2021.
It is assessment at 1415 and that is 30th June 2021.
Same order.
WPC 2227.
Have you found out, 1 minute, have you found out that
yes, I am
passed over
just,
matter?
Lordship, may kindly excuse me, I am
Still locating, okay.
there are so many matters, my lords.
Right, right.
I am very sorry, my lords.
No problem. 22272.
22272 of 2021.
This is assessment at 1718 and notice is 30th June 21.
Yeah, same order.
23176 of 2021.
Here, running page 14 is a notice, 1718, 3621.
Yeah, same order.
My lord, this notice has been issued by the joint commissioner. So that my lord, already my lord, order is there. Already covered, already my lord was earlier.
That is considered by replying the notice. That may be covered there. The lordship can dispose of in the matter, giving liberty to all these may be raised. That may be considered and be disposed of.
Because that has been joint commissioner.
Otherwise, not.
We are anyway quashing it, sir.
Yes, that is.
We are anyway quashing it. If they issue a fresh notice, the joint commissioner, they are asking for trouble. Why should we anticipate what they will do? We are anyway quashing this notice.
Either way.
Right.
WPC 23177 of
Same order.
WPC 23711 of 2021.
Yes, man. Yeah. 23711. Yes. Here, my lords, the assessment date is 1617. And the notice is on 29th of June 2021.
Right. Same.
Annexer 1, page 9. Same order.
Same order.
WPC 23712 of 2021.
23712. Yes, my lords. Here, my lords, the notice is on dated 29/6/2021. Annexer 1 at page 10. And assessment year is 1617.
Right. Same order.
WPC 23905 of 2021. Sri Radharam.
23905. Yes, my lords. Here the notice is Annexer 1, 21 of June 2021, Annexer 1, page 8. And assessment date is 1617, covered.
Right.
Next, WPC 24023.
So, sir, if it is the same order, we'll just put all the writ petitions together and pass one order.
Yes, man.
That's much easier then.
Man.
Right.
Correct, man. 240.
Your Lordship, if you are passing a common order, I have to make a submission in that.
No, we are still calling out every matter individually.
Okay. Okay, understood.
WPC 24023 of 2021.
Yes, my lords. Assessment date is 1415.
Yes.
And the notice is dated 9/4/2021.
Right.
Annexer 1, page 9.
Same order.
WPC 24676 of 2021.
Here, my lords, 1314 is the assessment year. And notice is dated 21st of April 2021. Annexer 1, page 10.
Right. Same order.
WPC 25235 of 2021.
Be covered by the Supreme Court judgment, my lord.
All right. Same order.
WPC 25433 of 2021.
So that's yours, sir. Mr. Raj.
Yes,
logistic.
Man. 1 second, my lords.
25433.
I myself am confused. That is the ସେଇଟା ନୁହଁ ମୋ ଖୋଲି ଦଉନାହାନ୍ତି 254. Lordship may pass it over. I'll again. Why, Lordship?
All right.
Waste time.
Right.
Next WPC 25965 of 2021.
Lord, 3621, 1617.
That's covered by Lordship's judgment.
Right.
Sorry, the Supreme Court judgment.
Supreme Court judge. Correct.
WPC 25969 of
Also covered. That's also covered.
Covered. Right.
WPC
Same order.
25972 of 2021.
In this matter, just a minute. In this matter, my lords, there are three matters. In the first matter, 25972,
yes,
that is, my lords, covered by your Lordship judgment. But your Lordship would only refer to paragraph 7.1 of that CBDT circular, where they say that if it is less than
50 lakhs.
50 lakhs, no,
correct.
If it's more than that and less than 50 lakhs,
correct.
So this should be taken into consideration in this particular case.
Yeah, they will. So we can say in paras
7.1.
Okay. So in 25972, you say keeping in view para 7.1 of the circular. Right.
WPC 25973.
The same order may be passed.
Yes, 973 also. And 975.
975, my lord, here the satisfaction is a joint CIT. It's without jurisdiction, my lords.
No, but once it's after...
it's after 1/4, my lords.
Yes.
After 1/4,
no, but anyway we are quashing.
The new statute, my lord, it doesn't
No,
empower...
but sir, anyway we are quashing.
True, man.
So the circular comes in. Under the circular, if again they are going to issue with a joint CT, it will anyway go. We don't know what will be the new one that they will issue.
So far as the new act is concerned, it's the principal chief commissioner or the principal...
No, Mr. Kar, I'm only saying once we quash the notice, they'll have to follow their circular. If after following the circular, they go to the wrong authority, you'll again challenge it and it will get struck down.
Then your lordship is...
right
only
now, we are quashing it because of the Supreme Court judgment and the circular.
In all these cases, Annexure 1, and only 7.1 of that CBDT circular may kindly be followed also.
No, even for 25975.
25975.
All three matters, you say para 7. Okay.
That's a common order.
Actually, we should simply say instead of paras, by following the circular, that's enough.
Good.
Let them follow their respective paras, so whatever para applies.
Let's simply dispose of, because otherwise we are...
No, my lord, sir, I'm with great respect to Mr. Satpathy, my lord, unless that is clarified as your lordship have done in earlier cases. What has happened, my lord, in one of my cases, I'll show, my lord, the total tax effect is 15 lakhs. Still, they have issued a notice, my lord. Even during the pendency of this case.
Para 7. All right.
7.1, my lord.
Right, 7.1. All right.
WPC 26366 of 2021.
Here the notice is 31st March 2021, my lord. That is covered by more than 6 years and covered by this.
Oh, I see. Okay. 26366 in view of the judgment of this court. In Ambika and NC. That order.
More than 6 years.
The petitions are same. No, this is something else you're showing, sir.
This sort of after the judgment of the
I
Supreme
think the
Court.
last para is enough. Take the para 4 of this. Para 4 of this is enough.
WPC 26829 of 2021.
Hello, I've got the passover. That is WPC 25433. If your lordship may permit me, I can. 25433. Lordship passed it over.
Sri Logistics.
Sri Logistics, my lords. Here, my lords, assessment year is 1415, and the notice has been issued on 9/4/2021. And next one at page 13. So
there's one more passover of yours, sir.
Yes, I'm just hurrying. My lords may kindly permit.
Yeah, all right.
If your lordship.
WPC 26829 of 2021. Grihasti Udyog. 26829.
Amor.
No, this is, I think Mr. Karas.
26829. 26829, na?
Here it says.
Mr. Pati. Grihasti Udyog, yes. Grihasti Udyog. Yes. Yeah, my lords. Assessment here is notice is dated 25th of June 2021. Assessment year is 15-16.
Yeah, same order.
Same order and that circular.
Yes, yes, same order, sir. When we say same order, it will refer to the circular, it will refer to the judgment. Right, sir. And it will quash an extra one.
Sorry.
No, same. Right.
I am extremely sorry.
All right.
WPC 26837 of 2021.
That's also yours, sir.
Yes, my lords. Now I will not repeat. 142021 is the date of notice.
Call it one by one. Sorry, sir.
Sir, yes, sir, the notice is dated 142021 and the assessment year is 16-17.
Right. Same order.
WPC 26958 of 2021.
My lord, the notice dated 30th June 21 for 2013-14.
All right, same order. Right.
WPC 26964 of 2021. Vishal Ferrol.
My lord, notice dated 9 April 2021.
Right.
14-15.
Right, same order.
WPC 27147 of 2021.
My lord, notice dated 30th June 2021.
Right.
14-15.
Right, same order.
WPC 27150 of 2021.
My lord, notice dated 30th June 2021. 2015-16.
Right, sir.
WPC 27153 of 2021.
My lord, notice dated 30th June 2021. 15-16.
Right, same order.
WPC 27157 of 2021.
My lord, notice dated 30th June 2021. 16-17.
Right, same order.
WPC 27184 of 2021.
My lord, notice dated 30th June 2021.
7187 of 2021.
My lord, notice dated 30th June 2021. 16-17.
Right.
WPC 27521 of 2021.
Yes, my lord.
Sri Jagannath.
15-16.
Form.
15-16 ମୁଁ କହିଦଉଛି ତମ ପାଇଁ 15-16 30th June 21.
I think he is appearing in both for the petitioner and for the department.
No, but it's okay. He's helping you, sir. He wants to be one up on you.
Mallards?
He wants to be one up on you.
15. He was very happy. Today he has got bumper crop. 30th of June 2021 is a notice.
All right.
Assessment is 15-16.
Right.
Annexer 1, page 22.
All right. Disposed of. Same order.
WPC 27524 of 2021.
Good idea. Mallards here. Same. Mallards, sir. How do you say same? What is the assessment? He has not read the.
I have written here 16-17 and notice that
16-17. Can you simple? 27521 Mallards. 524. Give me just one.
No, 524, sir.
524, yes. 27524. Here, my lords. Yes. Sorry. 524, yes. 524. Annexer is. And yes, as 15-16 is the assessment year.
Yes.
And the notice is dated 6/7/2021.
All right. Same order.
WPC 30142 of 2021.
My lord, in this case, notice dated 31st March 2021. Assessment year 14-15. Here is the issue regarding jurisdictional issue. The 148 notice issued by the another officer and it is under the ITO income tax officer, my lord. Then it is filed transport to the CID Central Circle. So it is a jurisdictional issue. In this case, I file a petition for my lord in this case, stating therein for amendment of my writ petition, my lord. Because I have prayed for the regions to be given to me in 148. Tendency of the writ petition, they have intimated me the regions.
No, but anyway, 31st March, sir.
31st March 2021, my lord.
No, but 2014-15.
My lord.
So it's
here is a jurisdictional issue, my lord, to come any date.
Next week, it will
All right. 30142 of 2021, list on 18th. All right.
WPC 30496 of
The
2021.
interim order to be continued, my lord, in that.
Yeah, interim order to cut. All right.
30496 of 2021.
My lord, here is the notice for the assessment 1314, notice dated 31st March 2021, my lord. It is after more than 6 years.
Correct, correct. So this is covered by Ambika Steel. 30496, same as an Ambika Steel.
WPC 31630 of 2021. 31630.
This is covered by the Supreme Court judgment.
All right, same order. All right.
WPC 31633 of 2021.
This is covered by the Ambika Iron judgment, because the notice is issued after 6 years, relates to the assessment year 13-14. Notice is issued on 30th June 2021. So it is covered by Ambika Iron.
No, if it's 30th June, then this circular comes in, sir. If it's only before 1st April, then it will be covered by Ambika.
No, any which way, it is covered under Ambika because it is beyond 6 years.
No, it has to be a combination, sir. Because if it is beyond 6 years,
yes.
Because if you look at the circular, para 6.1, it includes 13-14, 6.2. It will be deemed to be under new laws. The 6-year rule will not apply. After 1/4, it becomes 10 years.
Very well.
So this is covered by the first order. That is Ashish Agarwal order.
WPC 31637 of 2021.
Same.
Same. Court. That is Supreme Court order.
WPC 31640 of 2021.
Same.
Supreme Court order.
WPC 31643 of 2021.
Same.
WPC 31646 of 2021.
Same.
WPC 31902 of 2021.
My lord, it is assessment 1718. A notice issued 12th May 2021.
Supreme Court order.
By
first order, first Supreme Court order. Right.
WPC 31966 of 2021.
It's covered. It's covered.
Supreme Court order. Yeah.
WPC 32020 of 2021.
It's covered by
Supreme Court order.
WPC 32023 of 2021.
Covered by
Supreme Court order. Right.
WPC 32025 of 2021.
Covered.
Right.
WPC 32027 of 2021.
Covered.
Right.
WPC 32031 of 2021.
Covered.
Right.
WPC 32033 of 2021.
Covered.
Or
circular also.
WPC
Yes.
32035 of 2021.
Covered.
All right.
WPC 32475 of 2021.
Here also, the assessment is 1718.
All right.
Rest, I think Chimaka will save.
No, not belongs to me.
Annexer 1 at page 10.
All right.
Dated 25th of June 2021. Here I want to bring your lordship's kind attention. They have, after this was stayed earlier, they on 12/6/2022, they issued a notice under section 148A(b). So
you will challenge that anyway, sir.
Yes, sir.
Yes. Right. Yes.
WPC 33414 of 2021.
That's covered.
Supreme Court order. Right.
WPC 33428 of 2021.
Covered.
Right.
WPC 33430 of 2021.
All right.
33657 of 2021.
Yes, my lords. Here the
Same.
assessment date is 1516 and annexure 1, 25th of June 2021.
Right.
Page 8.
Right.
WPC 33662 of 2021.
Yes, my lords. Here the assessment date is 1314.
Right.
And the notice has been given on 30th of June 2021.
Right. Right. Same order.
WPC 33716 of 2021.
Yes, my lords. Here the assessment date is 1314.
Yes.
And notice under section 148 was issued on 9/4/2021. Annexure 1, page 8.
Right.
WPC 33883 of 2021.
Annexure 1, my lord, assessment of 1415. 140 notice dated 30th June 2021.
Same order. Same order.
WPC 34652 of 2021.
Same order.
Same.
Same. Supreme Court order. Mr. Roy Chaudhary, it's your matter.
Well, that is 1516
Ah.
and 21st April 21.
Yeah. Same order. Same order.
Only, so let's say IPO has taken permission from JCI.
That's all right. Doesn't matter now. It's gone anyway. The notice goes. Right.
WPC 35606 of 2021. JK file. JK filling station.
That is also yours.
All are covered, let's say.
Covered. All right.
WPC 35926 of 2021.
Assessment 1617. Dated 28/6/2021.
Yeah, same order.
WPC 36305 of 2021.
Mr. Acharya.
It's covered.
Covered.
WPC 36532 of 2021. Puran Mallah.
Ms. Roy Chaudhary, I think it's your matters. Next two.
That way it is covered.
Covered.
Yes.
36533 of 2021.
That is also covered.
Covered. All right.
36535 of 2021.
Yes, it is covered. Covered.
36536 of 2021.
536 also is for 1516 and then there is also that is the notice dated 31st March 2021. And that is also ITO has taken permission from JCIT.
So this is covered by our order.
Yes, sir.
So 36536
Yes.
is Ambika and Steel.
Yes, sir.
36538
That is covered.
Supreme Court order. All right.
37393 of 2021.
Covered.
Supreme Court order.
37394 of 2021.
Covered.
37459 of 2021.
Assessment 1314. Dated 16 March 2021. Beyond 6 years.
June.
Beyond 6
Right.
years.
All right. Covered.
WPC 37569 of 2021.
Covered.
WPC 37571 of 2021.
All right.
37574 of 2021. 37576 of 2021. 37578 of 2021. 37579 of 2021.
Right.
37640 of 2021.
It's covered.
Covered. All right.
37641 of 2021.
It's covered.
Yeah. All right.
37643 of 2021.
That is covered.
WPC 3764 of 8 of 2021.
Notice at assessment at 1516. Notice dated alert 25th March 2021.
Oh.
Annexure 1.
So it's covered by Ambika Steel. No, but that's not beyond 6 years. What's the? So it's 37648.
Yes, my lord.
Yes.
One.
Annexure 1.
It's 9th April, sir.
9th April, assessment date of 13-14.
That's all right. It's covered with Supreme Court judgment. Correct.
Yes.
WPC number 38071 of 2021.
Covered matter.
Covered.
38334 of 2021.
Covered matter.
Covered.
38335 of 2021.
Covered.
38424 of 2021.
Mr. Acharya.
38424 Milords covered.
Covered.
38427 of 2021.
Covered Milords by Supreme Court.
38430 of 2021.
Covered Milords.
All right.
38776 of 2021.
Yeah, my lords, the assessment date is 14-15 and the date of notice is 8/4/2021. Annexer 1 page.
Right. Covered.
WPC 38778 of 2021.
Yes, here my lords. Sorry.
8/4/2021.
8/4/2021. 13-14.
Covered by Supreme Court judgment.
WPC 38822 of 2021.
The year is 16-17, 31/3/2021. It is not one.
Date of notice is
31/3/2021.
In which one, sir?
Sir, 38822. Yeah, actually two notices have been given. One on 31st of March 2021 and another notice has been given on 8/4/2021 without withdrawing the earlier notice.
It is not
Annexer
covered.
1 and 2.
It is not covered because it is 16-17. So within the period of limitation, notice and issued.
Now that is correct, but the question is, how can you issue two notices under section
We
148?
can quash the first one and leave the other one open.
You'll also keep it in other day because yes, two notices challenging two notices here.
And Annexer 1 and 2.
All right. 38822, you say list on 18th July.
WPC 38823 of 2021.
It is well 15-16, 31/3/2021.
Same. Again, list on 18th July.
Yes.
WPC 38941. 914 of 2021.
My lord, this writ has been wrongly tagged in this batch. It is relates to another issue. It may be taken up on another day, my lords.
All right. List on 25th July. 38914 of 2021. List on 25th July.
WPC number 39693 of 2021.
My lord, this is covered.
Covered. Supreme Court judgment.
39814 of 2021.
Yes, my lords. Here the notice is dated 30th of June 2021 and assessment date is 13-14.
Yeah, covered.
Where the AC is not functioning, so
it's perspiring. Okay, we'll tell them.
39880 of 2021.
That's covered.
Covered. All right.
39883 of 2021.
Covered by Supreme.
Covered.
39886 of 2021.
Covered.
39888 of 2021.
Covered.
39890 of 2021.
Covered.
39893 of 2021.
Covered by Supreme.
39895 of 2021.
Covered.
39899 of 2021.
Covered.
39900 of 2021.
Covered.
3900.
39900.
39.
39900 2021.
Covered. Yeah.
39905 of 2020.
Yes, my lords. Here the notice is dated 30th of June and the assessment date is 14-15.
Right. It's covered.
WPC number 40104 of 2021.
Covered.
Right.
40106 of 2021.
Covered.
40110 of 2021.
Covered.
40115 of 2021.
It's covered.
40119 of 2021.
Covered.
40122 of 2021.
Covered.
40124 of 2021.
Covered.
40131 of 2021.
Covered.
40137 of 2021.
It's also covered.
40149 of 2021.
Covered.
40152 of 2021.
Covered. Right.
40154 of 2021.
Covered.
40156 of 2021.
Covered.
40157 of 2021.
Covered.
40166 of 2021.
Different case.
40166, my lords.
Yes.
It has to be withdrawn by me.
But
It has to be withdrawn.
40166, counsel the petitioner seeks leave to withdraw this petition, dismiss
Yes.
this withdrawal.
40316 of 2021.
Covered, my lord.
Covered. All right.
40321 of 2021.
Covered, my lord.
Right.
40323 of 2021.
Covered, my lord.
Right.
40324 of 2021.
Covered, my lord.
Right.
40917 of 2021.
My lord, here the assessment year 1718, notice dated 1/6/2021.
Covered.
40919 of 2021.
My lord, here the assessment year 1718, notice dated 1/6/2021.
Right. Covered.
41990 of 2021.
It's covered below. 41990.
WPC 567 of 2022.
Covered. Right.
594 of 2022.
Covered.
1608 of 2022.
Yes, my lords. It is covered because the annex, copy of there are 3 notices, my lords. Sorry, my lords. It's not covered. The first notice is issued 31st of March 2021. That is before 1/4/2021. Then again another notice on 1/4/2021. Then third notice on 5/4/2021. Annexer 1, 1A, 1B have been marked as
Anyway, we'll keep it for 18th.
Yes, 18th.
1608 18th.
WBC 1610 of 2021.
It's covered below. 1/4/21. Notice has been issued.
All right.
WBC 1611 of 2021. 2022.
1718 1/4/21.
All right.
WBC 1787 of 2022.
My lord, this is covered. Covered.
All right.
WPC 1790 of 2022.
Covered.
WPC number 1792 of 2022.
Covered.
All right.
WPC 2009 of 2022.
Covered.
Right.
WPC 2335 of 2022.
It is not covered, my lord.
But the proceedings initiated during the period of a stay, interim stay, may be taken some other date.
2335.
Yes.
2335, keep for 25th July.
That notice is issued.
WPC 2482 of 2022.
Covered.
2828 of 2022.
The covered, my lord.
Covered.
WPC 2933 of 2022.
2933.
Sir.
My lords, here the notice, this is covered. Annexer 1 is the notice dated 9/4/2021.
All right. Covered.
WPC 3841 of 2022.
Covered.
WPC 4058 of 2022.
This will be retained because this is a separate matter. It's not 25th. Kindly add
25th July.
It is along with 38914.
All right.
Already.
25th July.
WPC 4059 of 2022.
Same.
25th July. Right.
WPC 4117 of 2022.
And here the assessment year is 16/7, and the data is 21 April 2021.
Covered. All right. Covered. Right.
WPC 4119 of 2022.
Firmal the assessment year 1819, notice order 21 April 2021.
Right. Covered.
WPC 4669 of 2022.
Well, 4669, here also it is covered.
Right.
Because the notice is dated 30th of June, 2021.
Right.
They have already filed amendment petition.
And I have filed an amendment petition, but I think
not necessary, sir.
Not because they have now issued a notice under section 148A. So liberty may be given also to
Yeah. So 4669, just add a line. Liberty is given to the petitioner to challenge the fresh notice.
Yes. Right. Under section 148A.
And section 148A of the Income Tax Act. Right.
WPC 4808 of 2022.
Covered.
4895 of 2022.
This is covered by Ambika.
The notice is 31/3/2021. Relating to assessment year 13/14.
All right.
And approval by PCA. Beyond 6.
Anyway, yeah, beyond 6 years. So 4895, it's quashed in view of Ambika Iron and Steel.
WPC number 5361 of 2022.
Right. So I pray this matter may be taken up on the 18th, because here, my lord, the tax effect, my lord, is less than 50 lakhs. My lord. They have given a reason. May I just hand over your lordship the two reasons which they have given, my lords. The accommodation entry is only 15 lakhs. And 7.1 of the CBDT circular says if it is more than 3 years and less than 50 lakhs.
All right. Keep it on 25th.
25th. Any day can be.
25th. List on 25th. This is 5361.
5361.
Correct.
2022.
Yes.
May I just humbly pray those two reasons may be kept on record.
We'll keep it in the file.
WPC number 5507 of 2022.
Covered.
WPC number 5528 of 2022.
Mr. Mahapatra. 5528. Yeah, 21/4 and 14/15. All right, it's covered. Right.
WPC number 5680 of 2022.
Covered. All right.
WPC number 5815 of 2022.
Covered.
WPC number 5817 of 2022. 5820 of 2022.
Right.
Thank you.
5821 of 2022.
Right.
6123 of 2022.
Covered. No, 6123. The curse.
This is 1617.
No, this is 6123.
6123.
6123, my lords. It's covered, my lord. Your lordship will only indicate that CBDT circular 7.1.
No, we'll just say CBDT circular. Sir. Yes. That's fine.
All right. That's covered.
6136 of 2022.
6136, my lords. But here, this is covered by Nutan because this is assessment year 13/14. Notices issued on 31/3, my lord. If your lordship would see, my lord, here in Nutan, your lordship have taken note of the Supreme Court judgment and then held that if it is prior to 1/4 and more than 6 years, that has to go, my lords.
Right.
Your lordship may.
Yeah. You say, in view of the judgment in
here the, my lords, assessment year, my lord, Annexure 1, page 14 is the notice.
1 of 2022 bracket Nutan Bhushan Jena versus the Principal Commissioner of Income Tax. The impugned notice, which is issued on 31st March.
Sorry, my lords, it was on 31st of March 2021.
For the assessment year 13/14.
13/14. That's directly covered by a lordship.
Right.
WPC number 6137 of 2022.
6137, assessment year is 15/16 and the date of notice is 31/3/2021. But the satisfaction is of the additional CIT, my lords. Here, my lord, the chief commissioner, more than 4 years, it's the chief commissioner or the commissioner.
So Ambika Iron.
My lord, Ambika Iron will cover, my lord.
Yeah, in view of the judgment in Ambika Iron, since the impugn notice has been issued by the additional CIT.
May I just hand over Ambika Iron?
It's there with us, I think.
My lord.
Anyway, you can hand one more.
My lord.
And not the CIT, the impugn notice is quashed. Right.
WPC 6221 of 2022.
It's covered by a lordship. I'm sorry.
No, Lordship, this is my matter. In this case, what happened is, in addition to 148 ground, there is another ground of non-existent company. Your Lordship, the notice has been issued to a company which has been dissolved and strike off by the ROC in the year 2001, Your Lordship. That is 20 years ago. And the notice has been issued to this company. Lordship, it is in my own case before the Delhi High Court on the same and the identical facts.
No, what's the impugn? 1 minute. Which is the impugn notice?
Assessment of 13/14/8/4/2022.
No, which annexure is that?
Your Lordship, annexure number 5.
Running page 55. Lordship, kind evidence.
Your Lordship, my bad, Your Lordship, is annexure P6. P6.
Yeah, but it's 1/4. The notice is dated 8/4.
Yes, Your Honor.
Yes, Your Lordship, I agree. But the problem here is with respect to the jurisdiction, Your Lordship, you cannot issue a notice to a non-existent company, Your Lordship. Your Lordship.
No, but who's challenging it? I'm not able to understand. Why are you challenging it then? If the company is non-existent.
Your Lordship, the problem is with respect to section 179, which may impose a liability on the director. And moreover, if the case
So
is
we'll keep it on some other day.
case, then
List on 25th. We'll list on 25th. All right, list on 25th.
WPC number 6.
We listed on 25th because let the revenue council take instructions. Right.
WPC number 6302 of 2022.
6302, my lord, is Supreme Court judgment, my lord.
All right.
And
Supreme
CBDT
Court
circular.
judgment. Right.
6306 of 2022.
6306, my lord, the assessment year is 1617. And the date is 31st of 3/2021. So the satisfaction is of the additional CIT. Is the joint commissioner
So additional CIT that Nutan or whatever.
Sorry.
But within 4 years, it has been issued
No,
within 4 years.
my lord. 1617,
No,
31.
but it's by the additional CIT.
Additional CIT is a authority.
But if it is more than 4 years, then the has to be
If it, within 4 years is a joint commissioner. My lord.
Yes.
If it is more than that, then the commissioner takes over.
Yes,
But here, my lord, it is 4 years.
Yes.
And the additional CIT gives
additional
it, my lord.
CIT joint can same, my lord.
No, your lordships in Ambika Steel have differentiated that, my lord. A review was filed, your lordship had said that
He's
since-
higher than just
maybe, my lord, your lordship,
first.
he may be holding in a higher post, but the hierarchy, my lord, is taken care of in the statutory provision of old 148, my lords. Within 4 years, joint commissioner.
We'll keep this on some other day then.
My lords, my lords.
6306. Right?
Yes, sir.
6306, 25th July.
6306.
25th July.
6494 of 2022.
64? No, 6494, my lord. That will be again covered, my lords.
Covered.
6495 of 2022.
6495, my lord, is covered, my lords.
Right.
6500 of 2022.
Covered, my lord.
Covered.
6708 of 2022.
Covered with,
Covered.
6810 of 2022.
covered by Ambika Steel man. Annexure 1, after beyond 6 years notice has given. Annexure 1, 1314.
No, which year? What's the date of the notice?
31st March 2021.
All right. In view of the
For
Ambika
Ambika-
Iron and Steel. 6810 Ambika Iron and Steel, it's squashed. All right.
WPC 6960 of 2022.
Covered.
WPC 6964 of 2022. 7054 of 2022.
Okay, man, let's cover. And next, sir, one is the notice, 30th of June 2021. And the assessment year is 1415.
All right.
Yes, ma'am.
WPC 7328 of 2022.
Covered, my lord.
All right.
7557 of 2022.
How many? Nine. So, Mr. Collins, I'm on nine.
7557.
Covered. All right.
7561 of 2022.
7561 is also covered.
All right.
7564 of 2022.
Covered.
Right.
7567 of 2022.
Covered, my lords.
Right.
7576 of 2022.
Covered, my lords.
7576 is
7576.
Yes, my lord. 1617 assessment year.
Yeah.
31st March 2021.
Right. 7646.
7646.
Covered.
Yes, my lord.
All right.
7673 of 2022.
Well, this is assessment of 1450. Notice dated 31st March 2021. It is under jurisdictional issue. Notice issued by the ITO Ward 1, but the assessing officer is the jurisdictional central circle. He has to give his satisfaction. Similar matter, your lordship posted 20th. Let me tag with that case. Similar issues tagged on 20th July matter.
20th?
20th July, this 28th. 30142 of 2020.
We've been adjourning either to 18th or 25th, sir.
18th July.
18 July. All right.
Entry matter to be continued.
I may pardon, my lord. 7576. Your lordship, it is assessment year 1617. 31st March 2021. So within
My permit. Lordship, this issue, notice issued on 1st April 2021, my lords.
1st April.
So yesterday, my
That is
lords.
covered. Been covered after.
Right,
Yes,
right.
yes, yes.
WPC 7674 of 2022.
My lord, assessment for the 1415, my lord. Notice dated 31st March 2021.
31st March.
My lord.
Ah.
Assessment year 1415, my lord. Notice dated 31st March.
So it's covered by Ambika Iron and Steel. Who's for the revenue?
Yes, myself.
So covered by Ambika Iron and Steel.
Yes.
I've given a copy to your lordship.
Right.
WPC number 7676 of 2022.
My lord, assessment year 1314, my lord.
1415.
March 31st March.
The assessment of 1415, 31st March.
So covered by Ambika Iron and Steel, both.
WPC number 7684 of 2022. 7684 of 2022.
7684, my lord. 1450, notice dated 30th June 2021, my lord.
Yeah, so covered by the Supreme Court order.
One password, man. So WPC 21122 of 2021.
Mr. Rai.
That password, man.
WPC number 21122.
We'll just see it now. We can see it here.
Man. May I make a request?
No, I can tell you, sir, the notice is dated 9/8/4/21.
Yes, then your lordship is covered.
Covered. Correct. Right.
Lord, with great respect, may I just humbly pray, my lords? Your lordships have observed that the CBDT circular would be followed, my lords. May I just humbly pray, my lord, they should consider all aspects, and even if these things are once raised, my lord, a liberty may be given to approach your lordship. Otherwise,
That liberty is always there, sir. You're a whole army here.
Well,
I'm sure you'll challenge anything that is going wrong.
Before parting, my lords,
yes,
we must express thanks to both your lordships. So patiently, your lordship, one by one, have heard.
No, it's okay.
No, really, we are grateful.
You should thank the stenographers. They're going to have a tough time now.
And at the same time, Mr. Chimaka had a bumper crop today.
so we deserve a treatment also.
All right.
Greatly obliged.
Thank you.
Greatly obliged.
Thank you. I told him that. How many representatives? No, it's okay.
Weekly list for orders. Item number 1.
Last occasion, your lordship directed the respondent to pay 2 lakhs arrear.
Where is he?
Today.
Your lordship, as per the lordship direction, your lordship directed the husband or respondent to pay 2 lakhs towards permanent alimony to comply with the full order. Today with the difficulties he's giving 1 lakh and pray for some time because of his mother is suffering from cancer. Father is old. And
you take this 1 lakh, sir, at least. You
1 lakh. Your lordship, I pray for 2 months time to pay the remaining 1 lakh, and that will be the entire payment towards permanent alimony.
So what about the appellant, the wife and the children? He will only take from the beginning. He is taking his mother's plea that suffering from cancer, and he has already remarried and having children. Now playing with the appellants. And piecemeal manner that he is doing. And this is 5 lakh only as per his version. And there is a lot of amount he has to pay. Because
that is the money settled between
Where
the
is
two.
he?
No,
Where is he, sir?
not settled. Milord.
Where is he?
Milord, he has not come, Milord. He has, because of difficulty, he is unable to come, Milord.
All right.
On the previous occasion, your lordship was.
The counsel respondent hands over a demand draft. Is it a demand draft or? Bankers demand draft for ₹1 lakh to Mr. Bali, learned counsel appearing for the appellants, and undertakes that the balance amount of ₹1 lakh will be handed over positively before the next date. 6th September, sir. 6th September. Mr. Bahali makes it clear, states that even if the balance amount is paid, it will not settle all the claims of the appellant. This will be considered on the next date. All right. I have said that in the order.
Let there be final hearing, close the matter, because
First, let him pay this 1 lakh and then we'll.
yeah, he's taking always time taking.
No, so let us get that 1 lakh, sir. Let us
No,
get
1 lakh, he's not mercy, doing mercy to the appellant. He has enjoyed and
nobody
everything.
neither of us has said that anybody is doing mercy.
No, because the son is there, and how they both appellant and the son will survive.
All right. 6th September. All right.
Weekly list item number 2.
And let him remain present on the next date also.
If he does not pay, sir, he does not. If there is any default in making payment as directed, the respondent will remain personally present at the next date. All right.
Weekly list item number 2.
All the 3 petitioners, they are in the district judge cadre. Your Lordship kindly look to your Lordship's order in 27/4/2022. Your Lordship had directed the State Council to take instruction. While the writ application was pending, a judgment of the Supreme Court, Your Lordship must have known that which is squarely covered. And whether the question is whether the service rendered at the fast track court, whether that will be computed for the purpose of pension as well as the protection of pay and all this. But that judgment is squarely covered, and the registry of this honorable court has also moved the additional chief secretary to Government of Orissa Home Department for recommendation for allotment of GPF. But the prayer of the petitioner is to protect the pay scale in terms of that judgment, and also to allow the pensions to count the period of service. But this writ application was disposed of in terms of another order, which is a totally different, that is only exclusive for pension. And in that case, though the pension was recommended, but it was returned back. So Your Lordship directed that Your Lordship kindly see Your Lordship's order. Order dated 5/1/2022, other page. It's on recording there. That record is also very much before Your Lordship.
All right. So
now all these petitioners, while they were in service, in fact, the petition number 2 is continuing at present also. Petitioner 1 and 3 has retired in the meantime. Their prayer in the writ application. Yes.
All right. We just recall this order.
Yes.
Well, in fact, by the order dated 5/1/2022, Your Lordships have only disposed of the writ petition that in view of the order passed in the.
No, but that order is on something else.
Your Lordship may decide the writ petition.
That is exactly
keeping in view our objections made in paragraph 11 and 14 of the counter affidavit. So there we have stated regarding non-applicability of the judgment of the Honorable Apex Court. Running page, the paragraph 11 is a running page 38.
What I suggest to Your Lordship will recall the order and Your Lordship take up that writ application so that I can place also that very judgment.
IA number 1202 of 2022 and 1203 of 2022. Having heard on the counsel of the parties, the court recalls the order dated 5th January 2022 and restores writ petition civil 11008 of 2018 to the file. And then in the main writ petition, you say list for hearing on. September.
Your Lordship, direct to serve a copy of the counter. They have
copy of the counter affidavit be served on counsel for the petitioner forthwith. Right.
Obliged.
Weekly list item number 3.
Oh. There is a memo seeking withdrawal of the petition. The petition is dismissed as withdrawn in terms of the memo. Fine.
Weekly list item number 4.
So, may I please?
My lord, the affected people made a representation before the opposite party number 1, my lord, since long, my lord. My lord, the matter relates to addition of some more plots to the existing sand soirat, my lord. That the people made a representation, my lord. That is still pending.
Is this representation served on them?
Page 31, my lord.
Has it been served on them, sir? There's no proof of service.
There is no proof of service. By registered post. They have made it by registered post.
This is to the principal secretary revenue, but they may approach the collector.
No, collector has already approved, my lord. Annexure 1, order under Annexure 1 was passed and
No,
that
but
was approved.
there's nothing to show this has been served by registered post or anything, sir.
My lord, by registered post, my lord. Your lordship may kindly record my submission. By registered.
How will they check up whether they have a copy of this representation or not?
Let it come next week, my lord. I'll file the...
My lord, the Tahsildar has already allotted this Soirat source to somebody else. And as it appears that he is agreed by this order. That is Annexure 1.
So that person to whom it has been allotted has to be made a party, sir.
No, he is not a party, but if he so desires, he can challenge that order before the appropriate appellate authority.
We'll have to find out what is happening, sir.
Appeal provision is not there, my lord.
Not there?
No, my lord.
46, section 46 is there. Rule 46 is the appeal against the Tahsildar order. It is there, but if your lordship can dispose it off by allowing the petitioner to file appropriate appeal before this appeal.
No, should I record your submission that it's been allotted to somebody else?
That is appearing from the Annexure 1 itself in Soirat case number 02 of 2020. That is, I find it from the order sheet.
What is the date of this order?
Date of order is 15/7.
Page 24.
Date is not given, sir. 5/1/2020.
Yes, my lord, 5/1/20. As per the intimation to the highest bidder, he has submitted the consent letter and deposited security amount of so-and-so and EMD of so-and-so. Then
this will be time barred now, sir. 5/1/2020 is going to challenge now.
You can, that time factor your lordship can take.
It appears that the petitioners are agreed by an order dated 5th January 2022 of the Tahsildar.
In Soirat Miss case number 2 of 2020.
In Soirat Miss case number 2/2020-21. Mr. Manthi Learned, AGA informs the court that the said order can be challenged under Rule 46 of the
OMMC rules 2016.
Leaving it open to the petitioners to avail of such remedy in accordance with law, the petition is disposed of.
Wiki list item number 5.
Item 5 minutes, may pay minutes, let it be taken up on 25th minutes. It's an income tax assessment 140, it is slightly different minutes. 25th may I pay minutes. In the meantime, I will remove the defects.
Could defects be removed within a week? List on 25th July.
Okay.
Wiki list item number 6.
May I please? Item number 6.
Yes.
My lord, in this
This
case,
is covered with a new one, sir.
my lord,
This is covered by the
my lord,
new.
it is a case where already basing on new amendment rules, they have issued notice under section 148A, my lord. That is at annexure 4, my lord.
Yes.
They're giving time to compliance by 30th March 2022. I have given my the allegations that he has purchased immovable property valued 36,06,800 and cash deposit 27,55,000. So in grand total, it is comes to 63,61,800. Based that is the assessment of 1560. The department has a view that it is escaped from assessment, my lord. But this 36,06,800, my lord, it is segregated in 2 years, my lord.
But all this you have to give it in your reply, sir.
My lord,
we're still at the stage of show cause notice.
Well, I am giving my reply, my lord. In the reply, I have requested the authority to give sometime if there is some seems that there is some anything adverse to me to intimate me so that I can able to giving, my lord. Here is the very clear violation section 149 IB, my lord, because the section says that There
So
should be
you have not
estimate.
replied to the notice yet. Where is your reply? Where is the copy of your reply?
Page 38, Annexure 5.
No. The notice is dated 31st March.
Well, 31st March 2022, it is order under section 148 AD, page 6, Annexure 6, page 40.
That's not an order, sir. It's a notice.
Order under clause D of section 148A of the Income Tax Act 61. Page 40.
1-4, no?
Page 40, Annexure 6.
Annexure 6, your lordship.
Oh.
That is the order under section 41 AD.
AD, my lord.
So you've not given him in 1 day's time?
Order has been passed, my lord. Based on the recommendation, order has been passed.
No, with 1 day's time. The notice was 30th March, I thought.
No, my lord. He has allowed to file a reply. Annexure 5 is reply, running page 38, have a glance, my lord.
In that reply, I have requested.
No, he sought for time, sir. What is this? 1 week's time? Because Annexure 4 is 23rd March.
Yes.
And this is 31st March.
My lord.
Yes, he's replied.
There's no time at all.
Yes, he has already replied his notice, my lord.
What has he replied? He wants more time.
Ask for time.
It is humble request account. Kindly have glance prayer, my lord. What is his prayer? Under the circumstances, humbly prayed the proposed procedure under 40 may kindly be annulled as agreed.
Oh, he's not asked for more time.
Yes, that is what
My lord, 39
and the answer
he's not asked for more time.
Yes, the answer is, my lord,
The
41.
assessee may be given
Answer is 41.
future further opportunity of
No,
submission.
that's different from saying I want more time.
My lord, the assessee may given further opportunity of submission of any other information
If
and
needed.
documents if needed.
If needed. That's very different, sir. That's the standard line.
So, my lord,
You're not saying that I don't have enough time. Please give me more time.
my lord, my only submission with that section clearly says there is a escapement of 50 lakhs. Here there is no escapement 50 lakhs. It is 36 lakhs only. It is only 2 years. How the 2 years transaction were taken in 1 year? How the issue notice like this? My respect to submitted
Yeah,
before
but
lost
if it's
that.
less than your circular itself says if it's less than 50 lakhs, you have to drop it.
That is his submission, Lord.
It is clear, it is mentioned.
No, that is his submission, but
That
order
is
has
said
been
it is
Lord,
there.
see, start from 40. It is more than that. He is saying that it's clubbed in 2 years. That is his submission. But the revenue find out that is not clubbing. He has not stated anything in the order that is clubbing. Thereafter,
You
he
can
has to
challenge
reply.
this.
Yes,
Submission based on the salary
Or
required.
you say since the impugned assessment order dated 31st March 2022 is an appealable one, the court is not
My lord,
inclined to
148 notice that is not applicable, my lord.
Yes,
This is 148 AD order. Thereafter 148. Thereafter order will pass.
Yes, separate.
Thereafter we file appeal.
Yes. He has a
That
second
is the
chance. Is there.
provisions.
Yes, second chance.
So
is
when
there.
148 AD, when I'm giving my application before the authority, my transaction is less than 50 lakhs, which is
No,
supporting
but they're
evidence.
not agreeing it's less than 50, sir. That's your contention, it's less than 50.
So based on the sell deed, my lord, it's the sell deed says that it is 36 lakhs a month.
All right.
Where he got 50 lakhs?
Yes.
It is divided in 2 years. In how
No,
in
this
1
is the
year?
notice section. Yeah. Considering that there are more stages to cross after the impugned notice under section 148 capital A bracket D of the Income Tax Act 1961 dated 31st March 2022. The court is not inclined to interfere at this stage, leaving it open to the petitioner to urge all the pleas raised in the present petition at the appropriate stage the petition is disposed of.
Wiki list item number 7.
Liable person is let's see. So without law. Let's kindly see the first order.
This case direction was given to me to file a counter affidavit. In the meanwhile, I have received the instruction from the Tahsildar, but I have to file it in shape of an affidavit. Lordship may grant me some time.
Encroachments around Hadigadia tank.
There is a tank and he says
Oh,
that is...
I have filed this against all the tanks in Cuttack city. So to clean it, because people are not, those tanks are not usable at all.
No, you want encroachments removed because your prayer is something else then.
Prayer is confined to only one Hadigadia.
No, in my read petition, I have given 5 examples, including Hadigadia and other tanks.
One, you have said clear the encroachment around Hadigadia.
Hadigadia.
Who are the encroachers? What is the encroachment?
So,
There is absolutely no such.
those are, unless the Tahsildar measured it cannot be.
No, not for measuring. Are there people there or what is the encroachment?
No, one person was constructing and Tahsildar had stopped it. One person.
Which are these you have said in your prayer to clear the encroachment.
My lord.
What is the encroachment?
Encroachment, some people, they have covered
No, who's the some people? Who are the people?
those. I have given the name of one, that Haragadia Pokori, I have given name of one person.
No, no. Where is that person made a party?
No.
You have to make them a party, sir. See, unless you make people who are going to be affected parties,
my lord,
we can't entertain a petition like this.
Then I will add them as parties. Also, add the RDC, etc. as parties according to the decision of my lord Justice of this Honorable Court, my lord Justice B.P. Das. Because RDC, etc., they are to be made party also.
The petitioner who appears in person seeks time to make amendments to the writ petition.
Right.
List on 11th August.
Weekly list item number 8.
May it please the
11th of my month.
May it please the Lords.
Yes.
Here, my lords, the National Faceless Center, without complying 144B, the mandatory provision clause 21, passed the order of assessment, that is Annexer 1. And I have given the copy of the e-proceeding. My lords, before passing an order of assessment facelessly, they have to give me a notice under section 144 that I am going to pass an order.
Anyway, notice, Mr. Chimanka accepts notice and seeks time to file a response within 4 weeks. Rejoin to Finny before the next date. Till the next date, no coercive steps shall be taken against the petition.
Oblige me.
21st September.
Madam. Extra copy I'll solve within 3 days.
Weekly list item number 9.
May I please your lordship, my lord. New notification, my lord, 2022, my lord. Already this honorable court, my lord, struck down that notification 2016, my lord. That judgment is before your lordship, may kindly see that judgment, my lord.
That's okay. This is a new notification, sir.
My lord.
This is a new notification.
New notification, my lord. Same notification, same clause.
Anyway, we'll have to issue notice. You say notice, Mr. Pari. Where is Mr. P.K. Pari?
Already soft copies, my lord, to the master plan.
No, he's not even here on. Mr. Pari, you accept notice for one.
Yes, my lord.
Mr. Why is State of Orissa a necessary party here?
I will already sort the standing council transport also stop the copy to the state.
No. Why is the state a necessary party?
State. This is the transport department, my lord.
No.
Secretary transport.
How are they concerned with this validity of the central statute?
Your lordship say state transport commissioner, your lordship 3 and 4, your lordship say. I'll take. Already
are they necessary parties? So 3 and 4, are they going to be able to defend this notification?
They have collecting the fees, my lord. What happened, my lord? The renewal application is pending. Let them interim, my lord. There is the order of this honorable court interim. Let them allow my fitness, renewal of fitness. Vehicle is standing, my lord. We are the poor person filer.
Nothing. You pay it without prejudice to your rights and contentions to be subject to the result of the petition, sir.
My lord, your lordship say without collection of fees, your lordship interim order in earlier 2016, my lord. This is the order. This is the order, my lord. I am showing.
So these are not the truck operators will pass on the cost to the actual transporter. They are not going to bear this. This is like toll. If you are sitting in a taxi which has to go through a toll, the taxi driver will ask you only. He will pass on the cost, sir. He's not going to pay from his own pocket.
Without prejudice, without interim measure, my lord, without prejudice, let them not collect. They not to insist that amount, my lord. That's all.
No. How much is the fine?
12,200 rupees. Now it is increased to 12,000. Your lordship increase 12,200 rupees.
Since when has it happened, sir?
My lord.
Since when is it happening?
Your lordship, see the rule.
What is the date of the notification? It's 4/10/2021.
2021, my lord.
Almost a year ago.
No. 21. This is effect from April. Your lordship, see the notification.
Even now we are in July, sir.
No. This is the notification.
Last 3 months they've been collecting.
No. That notification is, my lord, April. Effect from April 2022.
Sir, my arithmetic is very poor. Between April and now, how many months have passed?
3 months.
3 months have passed. Even I thought it was 3 months. You agree with me?
My lord,
in these 3 months, what has happened?
The vehicle is standing, my lord. No, not yet been considered. Your lordship,
one vehicle may be standing. There are so many vehicles passing through Orissa. What are they doing?
Your lordship, my contention is saying that the vehicle is standing, my lord.
So for 1,200 rupees, the vehicle is standing, or 12,000 rupees.
12,000 rupees.
It's a lorry, correct?
Lorry, my lord.
So it's carrying cargo.
Your Lordship, lorry cargo, my lord. Your Lordship, 12,000.
You will be collecting it from your customers, sir. Please.
No,
Don't
Your
tell us that
Lordship-
you will pay it out of your pocket.
Then kept, your Lordship say that kept in the, I will deposit without prejudice, my lord.
That's
Your
all.
Lordship say.
That's
Your
all.
Lordship say without prejudice, your
Yes,
Lordship
yes,
kept
yes.
intention.
All payments with notice. Mr. Pari accepts notice for opposite party number 1.
I am appearing for the
State transport. He appears for 3 and 4. Opposite party 2 is not a necessary party and is struck off from the array of parties. The amended cost title or consolidated cost title be filed within a week. Replies be filed within 8 weeks, rejoinder for the next date. And then in the IA 886 of 2022, all payments made of the impugned, what is it called?
Renewal of fitness, my lord. Additional fee.
All payments of additional fee made in the meanwhile for renewal of fitness will be subject to the outcome of the writ petition. The application is disposed of. How many such writ petitions have you filed?
Your Lordship,
one whole batch must be there.
50 cases. Your Lordship, right.
You got those numbers?
I'll give the number. I'll give the number. Your Lordship, your Lordship.
So in both these petitions, same order.
I'll give them.
All right.
Wiki list item number 10.
May I please, George? In this writ application, the petitioners are the inhabitants of the ward number 3, 4, and 5, just across the river Miller. The state has undertaken the project in the government land for a bus terminal. What's happened, Miller? There is only one pond is there. All drain water and other waters are drained to that pond, Miller. Now the difficulty is these petitioners has no grievance against the project development.
So the only problem is all of you want to vacate unauthorized occupants.
That is the government is to do unauthorized vacation of unauthorized persons.
Who are those unauthorized persons?
No, I am not against that, Miller. I am only confining my prayer. There is a pond. All rainwater and other waters are deposited there. Now government is, the contractor is going to fill up this pond by sand and moram. If that is so, Miller, entire rainwater and other water were blocked there in the village itself. My only humble prayer is let the administration...
Anyway, you have a representation.
Yes, Miller.
All right. The petitioner's representation, Annexure 2, will be examined by whom?
Collector.
Collector Katak. And after giving hearing to the petitioner and opposite party number 5, a reasoned order shall be passed there or not later than. Do it right away, Mr. Montri. 1st August 2022.
Till then, Miller, your Lordship may direct the OP5 will not fill up the pond. Otherwise, Miller, the water locked in the village itself.
We can't do all that, sir, unless there's some fact finding. How can we simply direct?
Till alternative arrangement. I am not want to stop the
first hearing without hearing anyone of the opposite side. How can we allow these kind of directions? How can we pass? If you want, we'll call all of them. They'll file counter, rejoinder. Then 2 months will go. Monsoon itself will be over. You decide what you want to do.
Let the collector decide.
All right. The petition is disposed of. The court clarifies it is not expressed in view. Right.
Wiki list item number 11.
This matter may come after 3 weeks because Mr. Misra, who was doing this matter, became the chairman of the standing committee of the Legislative Assembly. Therefore, the claimants were to engage some other lawyer.
All that is long ago, sir.
He himself
Yes,
This was told to us some months ago.
Yes, madam. Mr. H.S. Misra is also not there. Your Lordship may call it in 2-3 weeks after. I will file fresh wakalat and...
No. What is the matter about, sir? This is a 2002 matter, 20 years old.
Distress sales of this PIL matter, distress sale of the paddy.
My Lord's permission, one submission, if I make. This order was last passed on the 11th of April.
That's what I'm saying.
This PIL has now been pending for 20 years.
20 years. That's precisely what I'm telling him, sir.
My Lord.
Keep it to someday after 2 weeks, 3 weeks.
No. We are not adjourning. Sorry, Mr. Rao. We are not adjourning.
There's a note that I
The
have.
same submission was made some 4 months ago.
I know that
3 months.
April, that was.
Yeah, 3 months ago. There's enough time to make all.
My only prayer is because the Bakarat has not come. That
No.
apart, my lord, Mr. H.S. Misra is also out of country, my lord. He will be reaching on 20th. That is the problem. Either I will assist him or he will assist me. We will do it.
No. There's no question of that.
This 20th July he is returning, my lord.
Give me 10 days time to file the note.
My lord, I have filed a note of submission.
Where is that?
This codes. It's there. It's 23/11/21. Note of submission along with an additional affidavit I've filed. That was in
23/11/21. My lord. Correct.
That note, my lord, clarifies everything.
Correct.
Along with the additional affidavit that the state's policies have changed.
Okay.
In the way where the Food Corporation of India has no major role to play in the acquisition of any crops, the procurement of crops rather. It has now come to the, basically it is now the responsibility of the state government itself. To that effect, the policy of the government as well as the MOU both have annexed to the affidavit. If my lord permits, I'll place.
And this grievance was confined to a particular year.
This grievance was confined to the year 2002. 2001, 2002, 2 PILs were filed. 3721 of 2002 and 17037 of 2001. Then there was a difficulty of procurement. According to this Honorable Court's order, the FCI directly started to procure crops. But in 2005
Mr. Rao, what we'll do is we'll reserve orders. If you want to file a written note of arguments within 7 days or even 10 days, we'll give you 10 days time to file a written note of arguments.
I will do that, but what I renew my prayer that let it be any day after 20th of this July.
No, sir. Actually, this is a 20-year-old matter.
Not that matter. There are a lot of history behind it. My friend will agree. If the FCI is not shifting the liability,
see, you can always renew. See, you can take note of what are the changed policies. You can take note of the contemporaneous facts. You can make it more relevant to today's issues. You can gather more facts. We file a fresh petition. We'll always permit you to do that, sir.
Can I request you?
We will confine this to the year in which you are making the complaint about. We'll deal with all these submissions. We leave it open to you to always agitate your grievances for any subsequent year. And in the light of the changed policies.
As I understand, the changed policies have also come on record.
No, coming on record is one thing. Questioning them or asking for their implementation is another. Then you will have to add facts. It's better you file a fresh petition.
But the question is, it is a matter.
If you are so inclined, we'll permit you to file a fresh petition because of the changed policy and changed facts.
But that
because this petition, when it was filed, pertained to one particular year of 2003 and 4, is it?
2001, one pair was filed in 2002.
2001 and 2.
3 districts of the state.
Your lordship may call it on 25th, my lord.
No. Sorry, we're not adjourning it, sir. You say...
Lordship kindly see the prayers, my lord.
Yes.
In the prayers...
So we are not now, after 20 years, not going to refer matters to the CBI. All right. That prayer certainly we're not entertaining. 1, 2 and 3 we're not. Only 5 is relevant. Directing FCI to procure paddy directly from farmers instead of rice from millers as per provisions of food policy. This is a food policy of 2001, my lord. He is saying in 2022, the whole policy has changed.
In fact, 2015, it has changed.
Right.
Since 2015, the FCI is not directly procuring anything from the state.
The
state government is procuring that.
The present petition was filed way back in 2002, seeking inter alia mandamus public directions to the Food Corporation of India (FCI) to procure paddy directly from farmers instead of rice from the millers as per the provisions of single quotes food policy paragraph. The petition filed on 27 March 2002, that is more than 20 years ago, obviously pertained to the food policy of the relevant period, that is 2000-2001. Full stop. A written note of submissions has been filed on behalf of the state government
Food Corporation of India. Man.
No, there's also one by the state government.
That would be probably the old one. My lord, may kindly have a look at the order dated 27/1/2020, my lord.
What we'll do is, I think we'll have to narrate all this. Instead of take this off, you say orders reserved. The petitioners are permitted, the parties are permitted to file the written notes of submissions within 10 days. All right.
Weekly list item number 12.
Granted time till
10 days, sir, from today.
I may say 3 weeks.
Sorry, Mr. Rao. Actually, we've been very indulgent. All right.
In item number 12, I'm appearing through.
Item 11, appearance of innuendo noted by.
Yes. All right.
Item 12.
Item 12, I'm appearing through VC. This matter was listed before your lordships on 4th of July. We had received information that the opposite party number 1 had died. And I sought information to take, I sought time to take instructions from the petitioner as to whether he has really died or not. We could not get any information as such, but whatever information we have is that he has died, though he is being represented by Mr. Biswa Bihari Mohanty, advocate in this court.
He's here, Mr. Mohanty is here. Yes, Mr. Mohanty.
My lord, it's a fact, my lord. In 2016, he has died. And my lord, my lord, coming up with a miscase, my lord, that has come to my knowledge, my lord. I have come up with a petition for the substitution of the legal heirs. My lord, here, my lord, the order has been stayed since 2012, but no complaints of 17B.
No, there is no application for 17B either by the other side. There's no application which has been filed.
Then where is the question, sir? You not filed an application even.
May I just speak? If your lordships would permit me.
It's a case where the Lord Tribunal has directed for reinstatement and 25% back wages.
On behalf of the petitioner, if my learned friend will allow me.
Let them be substituted first.
All right, this IA number blank of 2022. You'll have to give a copy of this petition on the other side, sir.
My lord, I will give, but he appears on his.
No, but he can tell you whom to serve it here on. Whom should he serve this copy of the application on?
Sorry, my associate is there in the court.
No, I'm sorry.
For the reason stated, the application is allowed. The legal representatives of the opposite party, as stated in the application, are brought on record. The application is, okay. And then the main petition, you say, list for hearing on.
Could your lordship list it on the 27th? There's one matter which your lordships have fixed on 27th.
I know, but all these boards are heavy on these days. So
I'll take my chance if your lordship can take it up on 27th or the 28th.
We'll keep it on 3rd August. Sir.
Okay.
3rd August.
Could your lordship have it before the 30th, any date, 29th, 28th, 27th?
Or at 27th July.
Very grateful, man.
Weekly list item 13.
Item 13 from the petitioner side, I think my lords had directed him to serve a copy on me. That was served by WhatsApp an hour back. So my lord, I'll request some time. It's a PIL matter. Municipal corporation is one of the parties.
Yes.
Here, in fact, on the basis of submission made by the Council for the CDA that the municipality is looking into these illegal constructions that has been made, your lordship on 21/3/2022 was pleased to direct me to serve a copy on Mr. Naik.
Yes.
I'm sorry I couldn't solve it earlier, but today morning I solved it and I intimated him that the matter is today. And that was your lordship was pleased to direct this because of the fact of my reading in paragraph 4.6 at page 6 of the PIL petition, wherein I have stated that the Amin has inquired into the matter and Amin has reported that the illegal vending zone has been raised. It is by the side of the SCB Medical College adjacent to the boundary.
In July, right, 2 days. So you've got this today.
Just now by WhatsApp got a soft copy.
All right. Mr. Nayak states that he's just received a copy of the affidavit, is it?
No, my lord, the petition copy I have given him in the morning. But
And states that he
today,
needs
my
time
lord,
for instructions at his request list on 23rd August.
Obliged.
Obliged.
Quick list item 14.
14 when I requested some on a other day.
At the request of Mr. Satpathy, list on 14 November.
Quick list item 15.
Item 15 mailers, I have instruction to appear on behalf of BDA mailers. Recently, they received the notice. May pre mailers be taken up some other day mailers.
All right, Mr. Mahapatra, Alert Council appearing for the BDA. At the request of Mr. Mahapatra, Alert Council, the BDA list on 15th November.
Mailers?
15th November.
Obliged, so obliged.
Quick list item 16.
Item 16, due to my ill health, I am appearing in VC Milord. Lordship, permit me that I am suffering from viral fever. I need Milord a 7 days time to file rejoinder. They have already filed.
All right, rejoinder be filed before the next date. List on 16 November. All right.
Quick list item 17.
But this matter has become infectious lordship. This item 16.
All right.
That power has been drawn.
Sorry?
That the PL, this is a PL matter, lordship. That challenge that.
You're arguing 16 or 17?
16.
16 has been adjourned, sir. All right.
Item 17, sir.
17, I plead your lordship. Lordship, here, the claim of the petitioners has been torn down by the collector Sundargarh to record a water reservoir in the Mauja Aurabal Badibal in the district of Sundargarh under section 5B of the Orissa Morse Territories Officers Village Officers Abolition Amendment Act 1976.
Sir, a detailed counter affidavit has been filed.
Yes.
You want to file a rejoinder or you don't want to?
Lordship, similar facts and circumstances has been stated in the counter affidavit.
All right, listed for final hearing. Is a counter affidavit has been filed to which the petitioner states he does not wish to file rejoinder. List for final hearing on 22nd November.
22nd.
Quick list item 18. May I please your lordship?
22nd of this month. As your lordship directed on 12th April, my lords, I have filed an affidavit showing, my lords, the position as on today with regard to the expansion of the Acharya Harihar Postgraduate Institute of Cancer, my lords.
Awaiting specialized tool for the NEMA test.
Yes, my lords.
All right.
That is held up, my lords, at Dibrugarh. So therefore, my lords, they have not got the approval from the Atomic Energy. But if your lordship will look at annexure V series, my lords, I have given photographs of the machine which has already been installed from page 12 onwards. Pages 12, 13, 14, 15 onwards.
It has to become operational.
Yes, my lords.
No, my lord.
Because of the Assam floods, my lords, the specialized tools have been held up at Dibrugarh. I have stated at para 3.
While photographs have been enclosed with the affidavit filed by opposite party number 3 today, showing the installation of the PET/CT scan facility. There, it is stated that the specialized tools required for the NEMA test regulatory approvals from the AERB are awaited. Full stop.
Then your lordship may look at para 4 of my affidavit. What other things we have?
All right.
3 rest steps have been constructed.
Orders for hospital furniture and new ICU equipment has been placed, which will be supplied in a phased manner. Full stop.
And it was alleged.
When should we keep this? We should keep this in August.
Madam, page 7, kindly see, madam. Page 7 of the affidavit. The operating license plan to start the PET city operation by 4th week of this month. That apart also, the Lordship directed to the State Council last occasion regarding the filing of the affidavit regarding the current status of the procurement of the equipments for the medical facility at Balasore and the Barampur Malad. Para 2 of the last order, Lordship, kindly see. Order dated 12/4/2022.
We keep it on 16th August, sir. Let's see.
In the
List on
meantime,
16th August.
Can it be in the 3rd week of August?
16th is 3rd week. Okay, 23rd August. 23rd August.
As well as the comply the order dated 12/4/2022 by the London State Council also, madam. Para 2 will also be indicated.
By the next date, the State Council will file an affidavit regarding compliance with the directions issued in the order dated 12th April 2020.
Madam, obliged. Obliged.
My lord, I have got some submission to made in this case. I am appearing for Maitri Sansad. We are the letter petitioner in this case, my lord. There is the order by this honorable court had their order dated 12/4/2022 that the senior counsel appearing for opposite party number 3 is supposed to file a separate affidavit regarding the expansion of the Acharya Hariyar. I would draw your lordship kind attention to the relevant paragraph of the said order, my lord. Para 1, last portion of the order, where this honorable court has directed Mr. Ponda to file a separate affidavit regarding the expansion of the Acharya Hariyar post.
So this affidavit which he has filed today, he says something about that.
Yes, para 4 I have stated all.
The copy of the same may be given to me. So
All right.
I'll
It would be served on everyone, all the counsel for the opposite.
My lord.
Right in the first line. All right.
Obliged. List item number 20.
Item 20, my lord, Mr. Jena suffering from fever, kindly adjourn to any other.
Minutes in this matter appear for opposite party number 8. We have, the pleadings are complete minutes in this matter, and also minutes, we are told that the EIA and EMPA have already been approved in the 42nd minutes held in April 22. There is all the grievances have been settled by an expert body. That is the only thing what is remaining right now. EC is not being allowed minutes today because of the stay minutes granted by this honorable court. The affidavits have been filed by the ADM and the
Counsel, the petitioner is stated to be unwell. So, counsel, the petitioner is stated to be unwell. List on 2nd August.
Yes, ma'am.
All right. 2nd August.
List item 21.
will never noted in this case, my lord.
All right.
Item 21.
My lords, I have received the instructions. I need some more time to file the counter, my lords.
Counsel for the opposite parties.
My lordship, I'm appearing on behalf of the petitioners. I would only like to bring it to the notice of the court that it's already been 3 months until now the counter has not been filed.
No, there's an interim order subject to the result, my lord. Regarding the case, my lord, members fees of that has been disposed of by my lord.
All right. Last, we'll say it's the last opportunity. Counsel for the opposite party seeks and is granted a last opportunity to file a reply within 4 weeks.
14th of.
Lordship, can a shorter date be granted?
1 minute. I have not even granted a date. Rejoin to be filed before the next date. List on 17th August.
Weekly list item 22. Item number 22.
22, I am on the second, first sub item will achieve WPC number 5100/21. In that case, my learned senior has filed the rejoinder affidavit. The lordship specifically directed serve us till date we have not received the copy of the rejoinder affidavit.
I think, I believe I have served. I'll take instruction to that.
I have not received.
All right. Copy of the rejoinder affidavit be served on. Is it there with us?
My lord?
Let them serve the copy with rejoinder also, Union of India. They have done, didn't serve the copy.
Copy the rejoined affidavit be served and counsel for the other party.
Your Lordship is fixing the date, my lord.
13 September.
I am also appearing
In-
on item number 1, my lord, for opposite party number 7. The first notice, I believe we are also one of the opposite parties, but copy of the writ petition has not been served.
You are for opposite party number?
Opposite party number 7 is the connected dispute. That is WPC number 5100 of 2021.
Right, Mr. Jagabandhu Sahu,
Notice.
senior counsel appears for opposite party number 7. In writ petition civil 5100 of 2021. Copy of the writ petition be served on him.
Notice has gone, my lord.
We have not.
You appear with whom, sir?
I am appearing for.
No, with whom?
Feroscrap Nigam Limited.
Ferroscrap Nigam, yes, notice has gone to all the parties, my lord.
We have also not received. I am appearing for the OP number 4 to 6 in the sub item, Your Lordship. We have not received any notice, Your Lordship.
But requisites,
Petition be served on counsel appearing for opposite parties 4 to 6 as well as 7. Right. Replies, if any, be filed within 4 weeks, rejoined for the next date. List on the same date. 13th
Lord, 4 to 6 already filed the counter, my lord. And now they said
WPC number 111/49 by 2022.
11149 notice has gone subsequently. In 5100 notice has already been gone and they have filed the counter already.
Filed the counter.
The first petition we have not got the copy. That is what we are submitting.
All this,
The
4 to
first
6 and
petition.
7 in 11149 of 2022. What?
My lord.
Your Lordship, may tag along with identical cause of action 10750 of 21.
List with 10750 of 2021 on
Your
13 September.
Your Lordship,
Wiki list item 23.
Item 23, last occasion, my lord, directed to obtain instruction on the
It
steps
is, my lord.
taken pursuant to Annexure 8. I have received this instruction. They have prayed for some more time.
Lordship, in this matter, Learned AG has sought some time to seek instructions on the representation in the matter. Now, what has happened, Your Lordship, the notice hasn't been issued in this matter. And any delay of any sorts in providing treatment for these kids might turn out to be fatal, Your Lordship. Because all of them are pending treatment from and any other aid from the state government, Your Lordship. Even different high courts of the country, Your Lordship, the Honorable Delhi High Court, Honorable Calcutta High Court, all of them have stated it may take time to seek instructions on what facilities can be provided to these kids. In the interim, the treatment should at least be started for these
Where are
kids.
the other high courts ordered that?
I have annexed it with the PI, Your Lordship.
Where
May I
is that?
place, Lordship? At page 142, Your Lordship, the Delhi High Court's order. 142 of the PI, Your Lordship. May I read, Your Lordship? I am of the view that once it is an admitted position that petitioners are covered under the said policy promulgated by respondent number 1 itself, for the welfare of persons like the petitioners, they cannot be made to suffer. Any delay in commencement of the treatment may prove to be fatal and defeat the very purpose for which the above-mentioned policy was created. And therefore, of the considered opinion that interim directions for commencement of treatment of at least the petitioners before this court deserve to be issued. It is accordingly directed that the treatment be started forthwith by AIIMS or any other centers of excellence, as the case may be, details of which centers have been furnished by the Union of India in its affidavit dated 28/9/2021. This is the Delhi High Court, Your Lordship.
No. Just carry on. See, I don't know whether these carry on. Just read.
The direction to AIIMS and other centers of excellence to commence treatment of these kids would also include a direction to them to provide the necessary medicines to these children. The cost whereof will be borne by the Union of India. It will be the responsibility of Union of India to ensure that necessary funds are provided to all centers of excellence, including AIIMS, as and
These
when
directions
demanded.
were issued to the Union of India.
Pardon, Lordship.
So these directions were issued to the Union of India.
Union of India, Lordship. In the Calcutta High Court judgment, they have issued the same directions to the state government.
Where is
And
that? Where is
that? That is at page 158, Your Lordship. May I place? page 158 from para 2, Your Lordship. It is evident that due to their weak financial condition, the petitioners are not only suffering severely but face impending deterioration of health which might acquire fatal proportions due to the implicit nature of their malady. In such circumstances, this court finds it unacceptable that at least the interim treatment of the petitioners have not yet started. In such view of the matter, WPA 4016 of 2020, along with connected application bearing CAN 1 of 2020, are disposed of by directing the respondent number 3 to immediately start the interim treatment of these petitioners free of cost. The relevant party, Lordship. The cost of such treatment shall be borne by the state government in the interim, reimbursable on bills regarding the medical expenses being raised by the state government to the central government under the National Policy for Treatment of Rare Diseases, subsequent to the petitioners being officially included in such scheme. Now, what has happened, Your Lordship, because all this procurement of funds might take time, any delay in the treatment of these children might prove to be fatal is what is a burning issue, Your Lordship.
What did you do on the representation? We wanted you to, in fact, tell us what you did on the representation. It was a representation of 4th March, Mr. Mudli.
Yes, ma'am. From second paragraph onwards, in this context, it is to mention that as per National Policy for Rare Disease 2021, facility based at Center of Excellence Registry of so is done under supervision of Indian Council of Medical Research. This disease is not under routine surveillance considering the limited and lack of epidemiological data and lack of scope of confirmation facilities. This disease is grouped under Group 3B as the cost of treatment is very high and long-term treatment and follow-up report is awaited or has been done under a small number of patients. Hence, it is not covered under Rashtriya Arogya Nidhi. It is submitted that steps are being taken for constitution of a high-power technical committee to look into the matter.
No,
and
this is not one routine thing. This is nothing to do with car festival and this and that. These are people suffering. How many children are we talking about?
There are 15 children in the petition, Your Lordship, in the PIL, but there are other children in Orissa at large who are not part of the present PIL, Your Lordship.
Actually, we'll probably, you say it from the written instructions received by Mr. P.K. Mudali, dated 30th June 2022 from the Health and Family Welfare Department, Government of Orissa, it's plain that nothing has been done on the petitioner's representation made to the state government on 4th March 2022. Paragraph. Considering the seriousness of the issue and the fact that there have been orders passed directing free treatment of children suffering from Duchenne muscular dystrophy, bracket DMD, by the orders dated 14th December 2021 and 1st February 2022 of the High Court of Delhi in Writ Petition Civil 9684 of 2021, bracket Adhyan Jaiswal versus Union of India and batch, and of the Calcutta High Court orders dated 18th December 2020 and 3rd February 2022 in CPAN numbers 564 of 2021 in WPA number 4016 of 2020, as well as the order dated 25th April 2022 of the High Court of Patna in Civil Writ Jurisdiction Case number 8053 of 2021. The court is constrained to direct the Health and Family Welfare Department, Government of Orissa to arrange for what is involved in this actual treatment? Is this medicines or is it injections or what is it?
It's a steroid, Your Lordship. It is currently it is not being manufactured in India. It has been exported from the United States of America.
Imported from India.
Imported, Your Lordship. And the state, we have prayed for the state to procure funds to import these medicines, so at least all the children cannot be treated. The life expectancy of such children is from 2 years till 18 years.
No. What we are asking you is because in Calcutta, they say bills will be raised on the central government and central government will reimburse.
Right.
And in Delhi High Court also, it seems to indicate that the government of India is supposed to pay. So what is the exact arrangement?
Because your lordship, now this disease has been taken part in the
One
national.
minute, you just say notice, then Mr. Mudali accepts notice on behalf of opposite party numbers 2, 3,
4.
4 is some National Health Mission.
2 and 3.
2 and 3. Mr. P.K. Padi, Learned Assistant Solicitor General, accepts notice on behalf of 1
and 5.
4 also, sir. 1, 4, and 5. Paragraph, it is seen from the orders of the Delhi High Court that directions were issued to the Union of India to provide for the immediate treatment of children suffering from DMD. In the Calcutta High Court, directions were issued to the state government and for the expenses incurred by the state government to be reimbursed by the Union of India. Full stop. The court directs both the Union of India as well as the state government to inform it as to the arrangements that can be put in place to immediately address the needs of the 16 children, 15 children mentioned in this present petition for treatment for DMD. Since this is a matter of some urgency, court expects a positive response from both the Union of India and the state government. List on 1st August.
Actually, one more thing, if I may submit. In the Delhi High Court order, they have also directed a annual report of the PSU.
You'll have to serve copies of the petition on Mr. Padi and
I'll do the need. In the Delhi High Court order, annual reports of the PSU showing their CSR responsibility contribution.
We'll come to it one by one, please. Okay. Let's not multiply too many things in the short run.
Yes, sir.
Wiki list for hearing item number 24.
Reply along with me, Mr. Bobita Sahu.
Right.
Item 24.
Obliged.
Your Lordship, sorry to intrude in between. Your Lordship, just a small request. In item number 19, the writ petition number 6221 has been listed on 25th. Your Lordship, can the same be shifted to 8th of August because there will be some difficulty for me on 25th.
Shifted to 22nd August.
22nd August.
Right.
Obliged, Your Lordship. Your Lordship, one more thing, interim order may continue. Your Lordship.
All right.
Item 24.
Highly obliged, Your Lordship.
May please your lordship. This is a self-test matter, my lord. This matter appears today's list as per the order dated 8th July, my lord. This is a self-test matter. Matter relates to tax recovery proceeding, my lord. Proceeding initiated under subsection 7 of section 13 of the Orissa Self-Tax Act by the tax recovery officer Katak 1 East Circle Katak, who has no jurisdiction. In this writ application, my lord, I would like to draw your lordship.
Why did we place it before the regular bench the other day?
Yes, my lord. That is how it is placed today.
No. Why did we do that?
My lord has restored. CMAPL, it was dismissed.
I know, but there were many other petitions we dealt with that day itself and disposed of. Why did we keep this for today?
In those petitions, my lord, the assessment notices and orders were challenged. Those, my lord, has given the liberty to file appeals. Here, right. My lord, senior submitted that the recovery notice is under challenge. In fact, just to curtail the matter, recovery notices have been challenged on 2 grounds. That the person issuing the notice, the officer issuing the notice has not been authorized by the commissioner.
Right.
Second, after we have submitted that the authorization notification, then the rejoinder have been filed that has not been gazetted. So in fact, it has been gazetted, and that officer has been given the power for initiating these tax recovery proceedings. In fact, that authorization was given post facto. So that's the only thing here.
So how much is the recovery of how much?
2 crore. In fact, the assessment order was also challenged in writ petition. That writ petition has been withdrawn by the order dated 27 February 2019 for filing appeal. So
this can await the appeal then, this recovery?
No, my lord.
Till the appeal is disposed of, why should the recovery take place? If the main assessment order he is challenging in an appeal, this recovery should await the decision in the appeal.
He has these remedies before the appellate authority. There he can file an application for stay. So there he has to make
an appeal, sir.
My lord, I may be permitted to draw your lordship kind attention. First of all, I would draw your lordship kind attention to order dated 7th, 12, 2001, my lord.
Yes.
As has been passed in this writ application, my lord.
Right.
I would like to place, my lord.
Please place.
My lord. Sri P. Mahanti, additional standing
So
counsel.
all that you don't have to read, sir. What is the main portion that alone you read?
Main portion is that this writ application shall be heard along with OJC number 6414 of 2001.
All right.
As per this order, my lord, this OJC has already been heard and disposed of.
Correct.
By this honorable court.
Correct.
Permitting the petitioner to withdraw the writ application.
Sir, have you filed the appeal? That is the question we asked you.
My lord, I am obliged to your lordship that I have already filed appeal and appeal has already been disposed of in favor of the petitioner, my lord.
Show that order.
My lord, I am very much obliged. Meanwhile, the order of assessment has already been set aside, my lord.
Show us the order.
My lord, my lord. I would like to place that High Court order as well as the
no need for High Court order, sir. Just the appellate order.
Appellate order.
Please give him a copy, sir.
My lord. And a relevant portion finds place at page 22, my lord. Last paragraph.
This is set aside assessment, I believe.
Yeah, the assessment has been set aside.
That has been said. Whether thereafter the fresh assessment has been
not yet completed, my lord.
My lord, may I take instruction on this?
Let them take instruction. Once the assessment order is vacated, the notice of attachment is inoperative.
Correct.
Yes,
correct.
That's
my submission before your lordship. If they want to complete the assessment, let them complete the assessment. Then the fresh.
Yes,
fresh,
if that assessment order has been set aside, then yes, this recovery proceeding cannot survive.
Correct. It has been set aside, sir. This assessment is set aside. Last paragraph.
My lord. So my submission before your lordship is that
the present
the
petition
notice of attachment
challenges an order dated 25th August 2001. Sorry, challenges an attachment notice dated 10th July 2001.
My lord. By annexure 2.
Issued by the Tax Recovery Officer, Cuttack. Paragraph. While issuing notice in the present petition on 7th December 2021, this court directed that the present petition would be heard along with OJC number 6414 of 2001.
My lord.
On 19/12/2002, it was directed that no coercive action would be taken against the petitioner. Paragraph. The court has been informed that OGC number 6414 of 2001, which was filed to challenge the original assessment order dated.
It's by 27/2/2019, withdrawn for filing appeal.
No. What is the date of the assessment, original assessment order?
Order of assessment is dated 26th March 2001, passed under section 12(4) of the West
26 March 2001.
My lord, for the year 97-98.
For the year 1997-98.
Under the West.
Full stop. That writ petition stood withdrawn by the petitioner by an order dated 12th April 2019, permitting the petitioner to approach the appellate authority to avail of the statutory remedy of an appeal. Paragraph. Pursuant thereto, the petitioner filed an appeal, which has come to be allowed on 18 November 2019 by the Joint Commission of Sales Tax (Appeal) CT and GST territorial range. We'll stop. The operative portion of the said order reads as under A to A. Counsel for the petitioner informs the court that the fresh assessment is yet to be completed pursuant to the above order. Paragraph. Inasmuch as the assessment order pursuant to which the impugned attachment notice has been issued has been set aside, it is plain that the attachment notice cannot survive in the eyes of law. Full stop. Accordingly, the impugned attachment notice dated 10 July 2001 and all proceedings pursuant thereto are hereby quashed. Full stop. It will be open to the department to take appropriate steps depending the outcome of the fresh assessment proceedings. The petition is disposed of in the above terms.
My lord, notice of attachment is, my lord, be questionable.
Yes, please.
My lord, the annexure 2, 1 and 2 both will be questionable.
Correct, sir.
My lord, obliged.
Vehicle list item 25.
Maybe lordship. Last case lordship obtain the state to health condition of the appellant, file the IA, regarding the health condition because you are treated SC medical college since 17/6/2022.
What are instructions?
His condition is now stable and he has been discharged from the hospital.
Oh,
when last
that's your instruction.
Yes.
Then you withdraw this application.
See, I am,
He was admitted on 17/6 and has been discharged on 5/7/2022.
just 2 days before I am mentioned, let's say on 5th, discharge on 5th, let's say.
That's right. So you say IA 9/21 of 2022. Counsel for the applicant seeks leave to withdraw this application with liberty to file a fresh application if the circumstances so warrant. The application is disposed of as withdrawn.